Good morning, sir. Can you see and hear me?
Yes, I can. Thank you very much.
Thank you, sir. First, we will be hearing from Mr. Aujard. We heard from him last week, and there are co-participant questions remaining. So you'll be hearing from 4 sets of co-participants. First, Ms. Page, who estimates will be up to 20 minutes. Then Mr. Maloney, who estimates 15 minutes. Then Mr. Steen, who estimates 15 minutes. And then Ms. Oliver, who's between 10 and 12 minutes.
Right.
After that, we'll hear back from Mr. Smith. We have Mr. Aujard today attending by video remotely. Can I just check, Mr. Aujard, can you see and hear us?
Yes, I can, indeed.
Thank you, sir. Well, I think that's everything.
Yeah, thank you, Mr. Stevens. Can I just remind you, Mr. Aujard, that you're still on oath, even though there's been a break between you starting your evidence and now completing it this morning. So over to Ms. Page first.
Thank you, sir.
Thank you, sir. When you joined Post Office in autumn 2013, it was in the midst of a legal crisis, wasn't it?
As it was explained to me at the time, it was to take on a help with the mediation scheme. I don't think that the words crisis were used either in the interview process or as and when I joined.
Did you identify it as a crisis when you joined?
That said, it became apparent as my time at Hull continued that there was a lot of scrutiny around the mediation scheme in particular, and that was, although that was occupying some of my time, it was by no means the vast majority of my time. But the direction that I was given by Paula and Alice Perkins upon joining was that I was there as a corporate general counsel, and this, I don't believe the words crisis was used at any time, and certainly not in the first sort of 6 months or so.
Whether or not anybody else used the word crisis, you must have recognised as a lawyer that there were considerable legal challenges facing Post Office.
Yes, indeed. Yes, indeed.
And your task as General Counsel was to make sure that Board had clear advice on what they ought to be doing according to the law, yes?
Yeah, one of my tasks, yes.
You ought to have been the backstop, the brake on a natural inclination to cover up problems, hide them away, move on.
Part of my role is to be transparent and clear with the Board and inform them as to information that crosses my desk that they ought to know.
At paragraph 393 of your statement, no need to bring it up, you say this: the overall misunderstanding of the size of the issue led to the approach taken by Post Office when challenged, which was that there is no problem here. A comment that was, in retrospect, made by way of assertion and possibly in reliance on the presumption that a computer operates correctly unless shown otherwise, rather than by reference to more exhaustive investigations. This inevitably led to a situation that was more adversarial and less cooperative than it perhaps needed to have been, as well as the one that did not identify the problem quickly enough. Let's get real here, Mr. Aujard. There was no misunderstanding of the size of the issue, was there? The Board had notified the insurers of a litigation risk, and they were asking for advice on their personal liability. So it's not about a misunderstanding of the size of the issue. It's what you say next that's key, isn't it? It was a deadly presumption at work. The Board desperately wanted to believe that the system was working, didn't they?
If I could answer that question as follows. In terms of the size of the problem, that I believe is a reference to comment I make earlier in the witness statement about the mediation scheme and the size of the number of applicants that applied to that, which, although more than the board expected, was somewhat less than one would have anticipated if there was a widespread systemic error. At least that's I think how the board saw it. In terms of the presumption, I believe, and I'm not sure on what basis this belief is held, but I believe it was either from Linklaters or on Dickinson or possibly Cartwright King, that there was a belief within Pol that there was that the system worked as it should in all circumstances until proved otherwise. So absolutely correct. There was a presumption at all levels within Pol. That is correct.
And as you accept, this led to needless adversarialism.
As I say in my statement, it led to assertion rather than perhaps a detailed review.
Lord Arbuthnot has said that he believed relations with Post Office became, quotes, less open and more combative after you became interim general counsel. What do you say to that? So my involvement with Lord Arbuthnot was very limited. I believe I had maybe 2 meetings with him, possibly 3, but I believe it was 2. And I can understand why, from an external perspective, he might draw those conclusions. They were, however, I think, as a result of the actions taken in relation to the mediation scheme, and those actions were very much directed by both the Sparrow subcommittee and the board, as was seen in my evidence last week. Is the reality that your arrival timed with the board's reaction to an adjustment to the Clark advice and the very serious implications of that? The Pol board was going into cover-up mode, and that was the mood and the tenor of the leadership team that you were joining.
If it was that, I certainly didn't recognise it at the time, and I certainly would struggle to put my finger on specific instances of someone engaging in cover-up behaviour at the board level as a board.
Well, let's look at a few documents, and we'll start, please, with an email. It's about a report into John Scott's department. Now, John Scott is somebody who reported to you, isn't he?
Yes, indeed. I took over his reporting line when I joined Pol.
And your statement says that you had no concerns about him.
In his capacity in the role he was fulfilling at the time, which was principally in relation to physical security.
Yes, well, that's perhaps an important caveat, isn't it? Because if we have a look at a document, it was, I don't know if you accept this, whether I need to show you the email, but it was shown to you in the January of 2014 by Mr. Ron Warmington. And it's a document that it makes some very severe criticisms of Mr. Scott's department. Do you accept that Mr. Warmington gave that to you in January 2014?
Yes, I believe it's a document I asked Ron for, and it was a draft report prepared for Susan Crichton. And from recollection, it was heavily caveated, the most important caveat of which saying that he hadn't discussed any of this or interviewed anybody in that securities team.
Well, nevertheless, let's have a look at it, shall we? Pol 0034 4051. And if we just have a look at paragraph 1, it starts, Pol investigators and investigations are overwhelmingly focused on obtaining an admission of false accounting from the interviewed SPMR or employee. Poll investigators often appear to have paid scant attention to the interviewee's assertions of innocence or his/her reference to specific transaction anomalies. They seem to have shown little or no willingness to establish the underlying root cause of any given shortfall. This disinterest seems to be driven by the desire to, quote, get the money back from the SPMR, knowing that a false accounting conviction will provide a relatively inexpensive to poll pathway to that goal. In the event that an SPMR has not committed any criminal offence, then Clause 12 of the standard contract provides an equivalent pathway to asset recovery using civil law. And if we then just go down a little bit to paragraph 3. In none of the cases examined so far did any investigator record anything that indicated that there might be any widespread systemic problem worthy of investigation, despite similar allegations being made by different unconnected SPMRs. And then if we just go down to 5 as well, please. The overwhelming impression gained from reviewing the transcripts of investigative interviews is that the SPMR was viewed as an enemy of the business. The culture within the investigation team appears to be one of, quotes, a presumption of guilt when conducting an investigation, rather than an aim of, quotes, seeking the truth. See comments on the consequences of tunnel vision at the foot of this report. And then lastly, if we scoot down a little bit to the paragraph beginning by failing to investigate. I'm sorry, I should have found out what page that's on. I think we may have gone past it. If we could go back up to paragraph 5, please. Well, rather than scrolling up and down, if I may, I'll read it out to you, and if I'm wrong, I'm sure I'll be corrected. By failing to investigate those SPMR's assertions, or even to pay proper heed to them during interviews, the investigators have alienated all of them. It is that group, the SPMRs, who evidently still believe themselves not only to be innocent, but also to have been cheated by Poll, who really have become enemies of the business. That's the needless adversarialism right there, isn't it?
I think the adversarialism I was referring to in my earlier comments, which is part of the reflections in my witness statement, was around the attitude taken by Poll generally. This, I think, is a specific case of a specific team allegedly behaving in a certain way, as set out in this draft report. And I do agree this reads as though that team is adopting an adversarial approach to their investigation.
And a failure to investigate, as you also identified in your paragraph 394. That was their job, to investigate, and yet they were failing to investigate. And what's more, this document was identifying the fact that although the same complaints were coming up time and again, nobody was looking at this as a systemic problem. Now, whilst they were no longer carrying out investigations, this was telling you, was it not, that there were serious concerns over past prosecutions, wasn't it?
I have no specific recollection of what I thought of the document at the time. However, my belief is that I would have looked at this and asked a number of questions, such as why did Susan Crichton commission it? Was it an attempt by her to remove certain individuals from that team? I suppose the third thing I would have thought at the time is, it is a draft report that is heavily caveated and would at some point in the future, had I been a permanent GC and stayed on in the role, require further investigation to understand what was going on or what had gone on historically in that team.
Well, exactly. This is a document that required and demanded immediate action to make sure that it was properly understood, wasn't it?
So the document was provided to me by way of a historic piece of background. Here is something that Susan had...
Did it require immediate attention or not, Mr. Aujard?
My view at the time was, given it was marked as a draft document and heavily caveated, it is something that would have required investigation in due course.
In due course, I see.
Had I played for longer.
What in fact happened to the document so far as you are concerned, Mr. Aujard?
Sir, I believe this was handed to me by way of just more background information. My recollection is that I would have read it at the time and put it to one side, and that would have informed my thinking more fully about the organisation that I'd just joined. Beyond that, I can't say that I took any further action, or I can't recollect taking any further action in relation to this document.
All right, thank you.
There was another section of your statement I wanted to consider. You and indeed the poll board refer to an expectation gap in the mediation process. In clear terms, that meant the board wanted payouts to be minor, whereas applicants wanted compensation for their very substantial losses, yes?
Correct.
And when that was discussed in an off-the-record meeting with Sir Anthony Hooper, and we can bring that up, it's poll 0010-0335. He brought that matter to something of a head, didn't he? In paragraph 2, Ms. Venables opens the meeting and she says that she's expecting, as we see at the end of that paragraph, there to be outcomes in many cases which might be by an apology and or a small gratuitous payment. And if we go down to paragraph 7, we see your note of Sir Anthony Hooper's view, which was rather different. Quantum of the payments was discussed. Sir Anthony Hooper noted that the applicant's CQRs often painted a very distressing picture where there had been a loss of livelihood and other losses. His view was that should the evidence show that Poll had not acted properly, then the amount of compensation payable could be quite material. Now, he was telling Poll two things. One, that he might find that Poll had not acted properly, and two, that if so, Poll might owe a lot of money in compensation. Now, in effect, Mr. Aujard, that was the death knell for the mediation scheme, wasn't it?
I'm terribly sorry. Could I possibly have a look at the date on that note?
Yes, it's at the top, and I believe it's it's February 2014, 24th. There we have it. So,
thank you. So my recollection is that the expression expectations gap was in circulation within Poll as early as November 2013, and that arose really as a consequence of advice that Poll had received prior to my arrival, that its compensation paid should be paid in accordance with contractual principles. And I believe the expression, the guidance was 3 months maximum.
The question I asked Mr. Aujard, this was the death knell for the mediation scheme, wasn't it?
The expectation gap, which I think you're referring to as the death knell, here it had its roots.
No, I'm not referring to the expectation gap as the death knell. I'm referring to Sir Anthony Hooper's clear view that A, Poll might not have acted properly, and B, If so, they would owe a lot of money. That was the death knell, wasn't it?
I don't believe, I wouldn't characterise this as a death knell, no, I'm afraid I wouldn't. The scheme structure was such that the working group, which Anthony Hooper chaired, was there for the purpose of ensuring that cases were either mediated or not mediated. The amounts of money or compensation paid really were something that was arranged in the mediation itself.
Well, you accept, don't you, that following this advice, it was this that sent the poll board off to Linklaters. And the brief for Linklaters was to find a way to sack Second Sight and end the mediation process, wasn't it?
I believe the first brief for Linklaters was to examine the sub-postmaster's contract and opine on that.
Quite.
That was April advice.
You seek to make a distinction in your statement between, on the one hand, the litigation risk, and on the other hand, the risk that Horizon was, in fact, flawed, don't you?
At various points, I comment on both, yes.
That's really the sort of distinction that gives lawyers a bad name, don't you think?
In advising the board, I thought they needed to be advised on all the risks that they were presented with.
It's not a useful distinction, is it? The risk that a claim will be successful is inextricably linked to the question of whether what the allegations are saying is true.
That's absolutely correct, yes.
And let's put the notional risk into the real world. When faced with the risk that Sir Anthony Hooper might find against Poll, the board decided to spend a lot of money on Linklaters and then Deloitte, rather than continuing to spend money on Second Sight, didn't they?
I don't recognise that as a decision the board made.
Well, that's in effect what happened, isn't it?
So the board, in addition to retaining Second Sight and paying for their work to support the working group, also commissioned work from Linklaters and Deloitte. That is correct, yes.
The trouble with accepting the inextricably bound nature of the two risks is that Poll would have had to accept the possibility of admitting fault, wouldn't they?
In connection with a mediation matter?
Yes.
Yes. Not necessarily, no. I think the mediation was structured so that there could be examples where Poll agreed that it had failed in some way, perhaps in a training sense or through another matter, and that would lead to a successful outcome of the mediation. Indeed, there were a number of cases that went through the mediation scheme that did have successful outcomes.
So if I'm allowed, I would like to take the witness to one last document, but I'm conscious of the time.
If you assure me that this will take no more than a couple of minutes, you can do it, Ms. Page.
I'm very grateful. It's poll 0012 4350. This is a letter that you sent to the CCRC on the 5th of June of 2014. And it purported to be a summary of the Altman review. I think you've been shown it quite recently.
Yes, indeed, last night, thank you.
This appears to have been originally drafted by Susan Crichton before she left, is that right?
I believe it was originally drafted by Bon Dickinson from the bundle that I've been provided with.
Well, you picked up on it following a chaser, if you like, from the CCRC, is that right?
Yes, the chaser is unclear to me whether it was an email to Susan's email account that somebody had picked up, but it's clear from the context that they were unaware that Susan Crichton had left, so that's quite possible.
Now, this purports to be a summary. It's devoid of any mention of the issues which the CCRC really needed to know about, isn't it? It's devoid of any mention of the Clark advice, correct?
That is correct. It doesn't mention the Clark advice.
It's devoid of the concern that Mr. Jenkins had given misleading evidence, isn't it?
That's correct.
That was indeed mentioned by Mr. Altman repeatedly. And it's devoid of any mention of the case of Sema Misra, isn't it? Mentioned some 15 times in the Altman review.
That's correct.
You accepted from Mr. Stevens that the content of the Clark advice was startling. There's nothing of that startling nature here, is there? This is a bland, reassuring letter aimed at making sure it would all just go away. Do you accept that?
So the letter was in response to a specific request aimed at Susan, which I picked up, and it asked about progress with the review matters.
And the progress that you set out here is all peachy, isn't it? Everything's fine.
So this is the advice I had at the time from Brian Altman and Cartwright King. The advice that you're referring to earlier, the Cartwright King advice, I believe, of the 16th of July, was not something that was made visible to me for during my time at Pol, and it wasn't raised with I suppose Bond Dickinson, who drafted this letter, or rather, so this letter was attempting to respond to a specific request on a matter that they'd been dealing with Susan with.
Can I be clear, Mr. Aujard? The advice by Mr. Clark, which gives rise to the criticisms of Mr. Jenkins, that's dated, I think, the 15th of July. And I just want to be clear, are you saying that during the whole time that you were working at the post office, you did not see that advice?
No, sir. What I'm saying is that in my time at the post office, I was reliant on Cartwright King to advise me as to actions I should be taking in respect of the events that had occurred during.
Right. So you were aware of the advice.
I believe, sir, I saw the advice. It was appended to a briefing document that was provided to me on the second day I arrived at the post office.
Yeah, right. Well, that's what I thought. So that's why I couldn't quite understand the answer to this page's question. But the plain fact is your evidence that this is a document to which you put your name, but which was drafted by others. Is that it?
So this document was, from looking at the bundle, looked as though it had been prepared by Bond Dickinson with blanks in there for the number of cases going through the system. When the follow-up email arrived from the CCRC, those blanks were completed and this document was dispatched. And
this is my question as opposed to Ms. Page's, but you did not think about the contents of this letter independently? You just signed it? Or did you consciously understand what it was saying, and that was, you thought, an appropriate response to CCRC?
So I think it reflected the totality of my understanding of the issues at the time, and that understanding would have been informed by discussions with principally Bond Dickinson, but also to some extent Cartwright King.
All right. Is that it, Ms. Page?
Thank you, sir.
Mr. Maloney.
Thank you, sir. Mr. Aujard, I'd like to ask you about remote access, if I may. In 2014, the issue of whether Fujitsu was able to alter Horizon data without the knowledge of the postmaster was very important to Post Office, wasn't it?
Yes, indeed, yes.
In fact, it went to the heart of the integrity of Horizon as an accounting system, didn't it?
I think two issues went to the, essentially, yes.
Thank you.
Sorry,
and Second Sight was pushing hard for clarification of the position as to whether or not remote access was possible in general terms. Yeah. And you emphasised the importance of the issue at the board meeting of the 30th of April 2014, when Deloitte had been commissioned to review Horizon.
Correct, yes.
Yeah.
Yes.
And following that, you were also instrumental in ensuring the change order for Deloitte, which asked them to investigate the second site July 2013 concern that effectively branch ledgers could be amended remotely without visibility of the postmaster.
Yes, I asked them to investigate that in the revised set of instructions.
Yeah, because that was requested by Deloitte on the 6th of May 2014, and you actioned it on the 15th of May 2014.
Correct, yes, with the board's approval, yes.
And that was, of course, in keeping with what you had specifically raised during the board meeting the 30th of April.
Indeed, yes.
Yeah. Post Office had been trying to get to the bottom of the issue with Fujitsu so that it could answer the questions raised by Second Sight independently of Deloitte, hadn't it?
Yes, that may have predated me. I have no recollection of there being an ongoing dialogue with Fujitsu during my time at Pole.
Okay.
At that point, anyway.
Well, can I just ask you to have a look at one document? It's an email, and it's dated the 9th of May 2014, and it involves Mr. Andrew Parsons from Bond Dickinson, Mr. Roderick Williams, and Angela van den Bogert. And the reference is POL 20 304478. That's POL 20 304478. And if you could just focus in on the top of that, please, Mr. Aujard. This is Andrew Parsons to Angela van den Bogert. I've spoken to Roderick. The interim answer to SS question is... And it said, as requested at the working group meeting, Post Office are asked to produce a formal certification that it's not possible for anyone to access Horizon or Horizon Online and amend transaction data without the knowledge of the sub-postmaster or their staff. And the answer that was being given was, it's not clear what is meant by formal certification, but enquiries have been made of senior personnel at Fujitsu and in Post Office's IT team. There's no functionality in the Horizon system through either a front-end terminal or back-end server to edit or delete transaction data once it's been transmitted from a branch to the central branch data center. The transmission of this data is encrypted, transferred to the branch data center, and then stored in a separate audit server where they're sealed using industry standard secure protocols to ensure the data's integrity. Although it is possible to input additional transactions into a branch's account, e.g. by way of, say, a transaction correction, a sub-postmaster will always have visibility of these extra transactions as they are shown separately in the branch's accounts. A more detailed note will follow on this subject, but this won't be ready before the fact file needs to be submitted. So this is the 9th of May of 2014, and the position being adopted by Post Office, and essentially no deletion could occur without it being apparent to the postmaster. On the 23rd of May, you received the draft Deloitte report, yes?
Correct.
The report was 72 pages long, you may remember, including the appendices, so not a particularly long report. And can I just take you, please, to your recollection of the contents of that report as set out at paragraph 254 of your statement? I don't know if we're able to bring that up for Mr. Aujard so that all can see it. And so paragraph 254. That's great. I'm very grateful to the document manager for the hard work I caused her there. And this reads, just going down to just reading down, in the final draft version of the board briefing dated 4th of June, provided me there was reference to the issue mentioned at paragraph 243 above, although it appears to be stated in different and much more formal terms. In the section 4.2 headed specific comments, other key controls summary, Deloitte passed comment on what they refer to matter 3, namely the test proposition that baskets of transactions recorded by the audit store are complete and digitally sealed to protect their integrity and make it evident if they'd been tampered with. The headline comment in this regard is as follows: it appears that Horizon is designed so that its audit store is a complete representation of the counter transactions and audited events, and the data will be kept with integrity for 7 years. In their detailed comments, however, they go on to say that we have not identified any documented controls designed to prevent a person with authorised privileged access from deleting a digital sealed group of data and replacing it with a fake group within the audit store. They do, however, make the point that the audit store physically runs on separate specialist IT hardware which protects the data once it's written. In addition, they comment that the so-called Horizon feature in question has been assured under Ernst & Young's ISAE report testing since 2012. So that's the potential complication so far as the Deloitte report is concerned. And then at the next paragraph, paragraph 255, you say, as is referenced in paragraph 2017, you work closely with Leslie Sewell, the then CIO, and in relation to technical matters such as these, I and the other lawyers would almost certainly have relied on her and her team to decide whether such a lack of documentation was a significant issue or immaterial. I've not been provided with any papers that assist my memory in this regard, but my general recollection is that following receipt of this report, it was still understood within POL that changes made to the audit store left an indelible audit trail, and then you don't know the basis of that, is the final line of that paragraph. After Post Office received the Deloitte report, there was a Project Zebra action summary. Do you remember that?
I believe that's the document that I've been sent, prepared by Julie George.
That's it. And that was sent, I believe you had it before, but it's sent to you last night along with an email. And what the Zebra action summary essentially was, we have this report, what do we have to do as an organisation to meet its concerns? That was it, wasn't it?
Correct. It was a forward-looking piece of work.
Yeah, entirely. So can we just look at that, please? It's poll 3031409. And if we could just focus in on the header, we can see that, thank you, the authors are James Rees and Emma McGinn, and this is reviewed and signed by Julie George. It's version 3, and it's the 12th of June 2014. So it's about just over 2 weeks since you received the Deloitte report. It's about a month since the position was agreed between Roderick Williams and Angela van den Bogert and Andrew Parsons. This is draft 3, and you've looked at this document. I can perhaps summarise it. It identifies all the concerns that were raised by the Deloitte report and then says what action should be taken in order to meet those concerns.
Yeah, broadly speaking, that's correct, yes.
Could we go to, please, to page 6 of this report, paragraph 4.2.2. .2 is technical, so 4.2.1 is data retention, what's needed to be done about that. But 4.2.2 is data logging. And it reads, one point raised in this report was that it was possible for someone with privileged access to delete data from specific areas of Horizon. This is always a risk with individuals using admin or power user accounts and is a persistent risk, one that needs to be catered for in almost any organisation. Due to the sensitive nature of the information contained in the databases, monitoring of those databases should be put in place using technology to detect and record deletions and administer changes to the databases. If possible, alerts should be generated for mass deletions and high-level risk changes to database schemes. Recommendation remediation. The solution currently in place may be able to undertake the level of logging required within the Horizon solution. It's recommended that the current logging and logs are reviewed on a daily basis. This needs to be investigated further and the options on how to handle this defined through the risk management process and based on the solutions already in place or ones that could be procured to handle this. That's signed off by Julie George as version 3, and effectively what this says is there are no controls and we're going to have to do daily checks to make sure that we know about deletions. This is not about inserting transactions, is it, Mr. Aujard? And this is not about balancing transactions, it's about deleting transactions.
It's about creating, as I understand Deloitte to put it, fake digital signatures over fake information.
Well, it's also about deleting material, isn't it? If you want to go back to the start, I mean, I asked you, it's about deletions, isn't it?
Yes, in your story.
And then creating fake material afterwards. Mm-hmm. It's plain that these people in Post Office understood that data could be deleted and that would not be immediately apparent to the Post Office, let alone postmasters.
Correct, that's what this implies.
Yeah. And of course, we've heard other evidence from Mr. Williams that Post Office really only appreciated this after the Swift review. But this is something different. Did you see this document in 2014, Mr. Aujard?
I have no recollection of seeing that document. That's not to say that it either wasn't described to me or sent to me, but I've had nothing to make me jog my recollection in that regard. I would say that from recollection over, Julie George was part of the team that was tasked with looking at what should happen following receipt of the Deloitte report, again from recollection.
Yeah, and were you part of that team, Mr. Aujard?
I was the chairman at that stage of the Risk and Compliance Committee.
Right.
Which received reports.
If you had seen this, would it have been incumbent on you to correct what appeared to be the public position of Post Office in respect of the concerns of Second Sight?
If I'd seen this, I think it would have been incumbent on me to talk to both Julie George and her boss, Leslie Saul, and ask what this meant in practice. For example, one of the things I think she comments on is people with requisite access rights. So an obvious question, I think, to ask is, are there such people with requisite access rights, or are such access rights separated? Yeah. Four eyes principle. So I have no recollection either of taking that action. I may have done or may not. I may have seen this or I may not. I'm sorry that I can't help.
So perhaps to summarise, you'd have drilled down, you'd have made sure as to whether or not people did have this access. If people did have this access, you would have made it very clear publicly that people did have this access, because this went right to the heart of the integrity of Horizon, as we established right at the start of my questioning of you.
I would have asked the technical people what this really meant in the real world. Right. Is this an issue or is this not an issue? Okay. That from what I know of my past behaviour, that's what I would have done. Had a conversation or more with Julie George, not Julie George, with
Leslie Saul.
Yeah, Leslie Saul.
Okay.
Yeah.
Well, let's have a look at an email. Sorry, go on.
So I was going to say, and if I did do that and I have missed something, that is a matter of deep regret for me.
Absolutely.
The public position as set out in the Bond Dickinson Roderick Williams statement is not consistent, in my view, with the statements here in circumstances where there is an individual who has the requisite access rights.
Thank you very much, Mr. Aujard. If I could just move on now. And can we look, please, at POL 20346 POL 20346 I'm very grateful for the focusing in. It's from Julie George. It's the 17th of June, 2014. So just a couple of days after the Zebra Action Summary was completed. We can see that this Subject line is Zebra Action Summary version 3, the version we've looked at, and the attachment is Zebra Action Summary version 3. And it's sent to Rod Ismay, David Mason, Malcolm Zack, and Gina Gould. And it reads as follows. I've tried to call you, Rod, attached a draft summary of actions arising from Deloitte's recent piece of work on the Horizon system. Clearly, there is no blame attached anywhere, and this morning's meeting with Chris Day, Chris Aujard, Leslie and Malcolm focused on what we would need to put in place as an organisation to address overall assurance on all critical systems, starting with Horizon from the 1st of April. And it continues, detailing appropriate industry standards and controls our business should be following against a risk-based priority mechanism. And continues that, Rod, we'd be happy to come to Chesterfield, however it'd be better, more cost-effective if we could have a morning or afternoon in the next week or so at Old Street. We four will need to be comfortable that we have a plan going forward, including indicative costs of undertaking for Risk and Compliance Committee on 21st of July, which of course you chaired, Mr. Aujard, as you said. And we will need to engage with ExCo members. Is that the Executive Committee members?
Correct,
attached,
yes.
And they, we've seen their names, attached to verify and agree to support prior to the committee meetings. Gina, can you arrange a meeting between Rod, Dave, Malcolm and myself? Thanks. It would appear from that there, Mr. Aujard, that you were in a meeting that morning with the reviewer as well as Leslie, that would be Leslie Sewell, and you were focusing on what you'd need to put in place as an organisation to address the overall assurance on all critical systems, starting from the 1st of April of the following year, presumably, and dealing with the points raised by the Zebra Action Summary.
Yes, there was clearly a meeting in that morning.
Yeah, and you plainly will have seen the Zebra Action Summary that morning, and you plainly will have fed in to the need for things to be addressed here, for ExCo to become involved, and for Risk and Compliance Committee to sign everything off on the 21st of July. Were these recommendations followed, and were actions taken to ensure overall assurance on all critical systems, starting with Horizon from the 1st of April?
So my recollection is that this ended up being a matter to be discussed at the Risk and Compliance Committee meeting, and tracking was given to the internal audit team. A team was tasked with looking at changes that needed to be put in place in order to ensure appropriate assurance over, I'm imagining it's critical IT systems in the organisation. But I have no further documentation to show what other actions, what those actions were, other than a record of the fact that there was an agreed course of action in relation to these matters.
Do you not think to tell Second Sight, who'd just been told a month earlier that with that certification, as it were, actually may have got it wrong? It may be that they can delete and postmasters wouldn't be able to see all the deletions.
I think that again, from recollection, I've said in my witness statement, the sense from those that were reviewing the Deloitte report was not that this was a critical or a significant matter, and I do not know why that is the case. Clearly, the matter was considered and discussed by numerous people internally. It could be, and I don't want to speculate, but it could be that it was that there were no persons with the requisite access rights, and that was the reason, or there could be other reasons for it.
Thank you very much, Mr. Aujard. That's all I ask.
Okay, thank you.
Thank you, Mr. Maloney. Is it Mr. Steen next?
Yes, sir. Mr. Aujard, I've got a few questions to ask you. Can I start with, please, a little bit about your background? You'd worked in corporate law, mainly in mergers and acquisitions. Is that fair?
Correct. That's the reason I was employed at the post office, was for that purpose, because I was corporate financial services, and that was the role that was described to me predominantly, given the post office is a distributor of financial services.
And you'd also worked for individual companies such as the National Australia Bank, Royal London, Singer and Friedlander, and one stint as general counsel for a gold mining company. Is that correct?
Yes, that's correct.
Okay. Now, your experience of working for those sorts of companies were that the boards of those companies were curious, interested, engaged, possibly quite annoying because they'd try and get hold of you late at night and ask detailed questions before board meetings. Is that correct?
Correct, yes.
And in fact, you set out what I've just summarised at paragraphs 26 and 27 of your statement at page 12. I don't ask you to go to it. What you say about some aspects of matters in relation to the post office is that the decision-making processes tended to be more data-driven in your past employers rather than based on political concerns, such as how a minister or an MP might react to a given decision within the post office. Is that fair?
Correct, yes.
So do we take it from that the post office was often concerned about how it looked, its image and brand, rather more often the detailed concerns that you had found in corporate companies that employed you in the past?
In a company which deals with consumers, of course, there is always a brand concern. But in terms of the political angle, that struck me as different, not something I'd experienced before in other companies.
Now, the work of General Counsel, as you're aware, is to effectively be the senior lawyer, bringing together all of the different aspects of legal advice that are required and providing advice based upon that to the board. Is that correct?
That's part of the role, yes.
Yes. It is also, General Counsel work is involved in diminishing risk to the business and making sure there's a high standard of legal compliance across the business. Do you agree?
Compliance within the legal risk appetite, which is set by the board typically, yes.
Yes. All right. Can we have a look, please, at how you dealt with one particular matter? Do you remember that the working group was concerned about what was happening or what had happened to sub-postmasters' monies when they paid money into a suspense account, and whether that money had been taken into income or profit as part of the post office business? Do you remember those concerns?
Yes, those concerns, I think, started in mid to late 2014.
And Sir Anthony Hooper was particularly driven by those concerns, was basically trying to find out where on earth the money had gone. Is that correct?
I don't know whether he was concerned to find out where the money was gone. He was concerned to find out how the money was accounted for.
Well, perhaps that's a fancy way of saying where's the money gone. Let's have a look at a document that deals with your with the way that you dealt with that particular matter. Can we go, please, to POL 000 40805. And if we can go, please, to page 3 of 4 of that document. And scroll down a little bit further, you'll see there at the middle of page 3 that there's an email from you to Alistair Cameron, subject suspense accounts. Do you see that, Mr. Aujard?
Do indeed.
Okay. So the first part we don't need to deal with. You then go on to say, as you will see, I really need someone from your team who has technically switched on re-suspense accounts and can handle themselves in front of an adversarial audience. Okay? So you wrote that. Then you go on to say this. As you can imagine, I am concerned we give Second Sight no more information that is necessary to address the narrow proposition that money is missing from an SPMR account is somehow taken into our suspense accounts and then appropriated to our profit and loss. Now, you don't appear there to be suggesting that Paul should take an open and inquiring attitude toward these issues. You appear to be, on the other hand, trying to take a less is much better attitude towards these particular issues. Do you agree?
I believe I'm taking the approach that polls should answer their question, but not engage in matters which are extraneous to their investigation.
In other words, can we translate that as your advice as General Counsel to Paul was make sure that Paul doesn't take any risks?
My advice, I think, here is to not, this, I wouldn't characterise this advice. This is in the context of a newly arrived CFO who has limited background on the mediation scheme and the series of questions that have been asked about suspense accounts going back and forth. So I do acknowledge that it is abridged and abbreviated, and it it may be interpreted the wrong way. Indeed, it may have been read the wrong way by Alistair Cameron. That wasn't the intention at the time. The intention was to make it clear that there was more to this matter than simply a factual request for factual information. I think, as it turns out, my concerns were misplaced about this, but as Alistair, I think, provided the information that Second Sight needed and ensured that the right technical expert was made available.
All right, in the middle of that long answer, do we take it that you accept that, as the newly arrived individual dealing with these matters, you are risk adverse?
I am relatively risk averse, yes.
Right. Let's move on then to one remaining matter, I think, which is an answer you gave to questions being asked of you by counsel to the inquiry when you were last here. You gave evidence in relation to matters previously on the 24th of April, and you were asked this. This is about the Simon Clarke advice of the 15th of July and the Helen Rose report. Okay? So, to Ms. Page, you said these words. In advising the board, I felt they needed to be advised on all the risks they were presented with. Those were what you said to Ms. Page when you answered her questions earlier. What you said to counsel of the inquiry about the Simon Clarke advice, and I will read it from the transcript, it says this. Following a meeting with Paula Venables, did you inform anyone on the board about the Simon Clarke advice of the 15th of July 2013? Your answer to counsel of the inquiry was this. Now, I'm afraid that I had assumed that this advice had been, or at least the contents of it, had been communicated to the board prior to my arrival. Then you're asked this question. Is it the same for this Helen Rose report? Yes, indeed, yes, was what you said to Mr. Stevens, counsel to the inquiry. Now, help us understand a little bit more about what you mean by this. Are you saying that you can think back now some 10 years and you can think back to yourself sitting at a desk somewhere within the post office organisation, and you can think back to you assuming that the Simon Clarke advice on the Helen Rose report had gone to the board? Is that what you're trying to tell us? You can remember assuming something?
No, I think I was answering the question. What was my the question I think I was being asked at that stage was, did it occur to me to make the Simon Clarke advice available to the board? And I think in circumstances at the time, day 2 of a new role, with this being an appendix to a large document, I would have thought that would have been flagged up to me very clearly. So if it required further action, absent that being flagged up to me, I would have assumed that there was no further action required to be taken.
Do you know what on earth you did in relation to this matter at all? Or are you just making an assumption that you've assumed something?
I was guided very much by the individuals I was dealing with at Cartwright King as to what the next steps were. So no, I wasn't just assuming things. I was listening and engaging.
Well, you're listening and engaging in a way that seems to completely ignore a red-hot topic of the Simon Clarke advice in relation to Mr. Jenkins. And your listening and concerned attitude in relation to that is not to urgently take it to the board. Do you agree?
As I said to the inquiry when I gave evidence last week, in the normal course of events, I would have expected something which is that is red hot and urgent to be flagged as such by the individuals briefing me. That is indeed the way general counsels operate. People brief and inform them of, oh, I'm terribly sorry the lights have gone out here. that is the way the role works.
But you also have personal responsibility, don't you? You have a responsibility to do your job. You are guided by the regulatory objectives in relation to your work as a lawyer, which are basically say for you that you need to take independent decisions on your legal advice. Do you agree?
Yes, indeed.
Right. So where is this that we can see that in dealing with red-hot topics such as the Clark advice and the Helen Rose report, which must, surely, you must think, go to the board, where do we see your role in that as being what, a complete incompetent, someone that failed to do it, someone that was so risk-adverse that you prefer to keep it away from the board? Which of those is it?
I don't believe it's any of those. I believe that, as I said to the inquiry last week, I was in a matter, as you put it, is red hot. It would have been flagged to me as such on arrival. My briefing, if you like, on arrival was that the actions that needed to be taken were in relation to the SIFT reviews, and that was the totality of action that needed to be taken. Had there been an indication that further action needed to be taken, I would have expected that to be brought to my attention in very, very firm terms.
Mr. Aujard, you rapidly came to the conclusion, as you and I discussed at the beginning of my questions, that this was an incurious board, a board that didn't operate the way that previous corporate boards that you had been involved with had worked in the past. They didn't ask the questions late at night and calling you irritatingly to get your advice. They didn't ask for short presentations before board meetings. So you were aware rapidly on assuming this role that this was a board that barely, it seems from your evidence, be paying any interest in matters, and yet you didn't make sure that they were aware of these high risks. Is that what we should find from your evidence, Mr. Aujard?
No, I think what we should find from my evidence is that I retained a dialogue with Cartwright King, and they indeed were also involved in ongoing collation of data that could or should be disclosed to persons that have been convicted of a criminal offence. And I would very much have expected that this matter, if it was significant, is something that they would have mentioned to me on not just one occasion, but more than one occasion. And that's not, to the best of my reckon, what happened.
Mr. Aujard, can we say as summary that the position appears to be that the executive team within the Post Office was essentially the main body for decision-making rather than the board of the Post Office? Is that what we can take from your evidence? That it was executives making decisions rather than the board?
No, I believe that would be incorrect.
All right, thank you. I think that we've explored that enough now, Mr. Steen.
Yes, sir, that was in fact the end of my questions. But anyway, thank you, sir.
Perfect. Ms. Oliver.
Thank you, sir. Good morning, Mr. Aujard. I ask questions on behalf of Gareth Jenkins. You gave evidence last week that you had been briefed by Cartwright King as to issues that had been raised in relation to Mr. Jenkins. Is that right?
Yes.
You were aware that he'd been used as an expert witness in past criminal prosecutions brought by the Post Office. Is that right?
Correct.
And you told us that you were aware that an expert in a criminal trial owed a positive duty of disclosure, including a duty to inform the prosecutor of any material that cast doubt on his or her opinion or that could arguably assist the defence.
Correct.
Were you equally aware of the duties that rested with a prosecutor who was calling expert evidence?
I don't know whether I'd be expressly aware, but by implication that must be the case.
Can I perhaps outline a few of those for you and you can tell us whether you were aware of them? Firstly, to satisfy themselves that an expert had been appropriately instructed by the provision of a written, relevant and detailed letter of instruction or terms of reference, setting out the issues and questions the expert was expected to answer. Were you aware of that?
I don't know if I was aware of it in those terms, but it would be something that would follow from the nature of an expert witness.
Thank you. Secondly, to provide explicit guidance as to what the expert was being asked to do and what material they were being asked to consider. Was that something you were aware of?
Not in those terms, but again, it would follow from the nature of the expert witness, in my view.
And thirdly, to inform the expert as to their relevant duties and to satisfy themselves that these had been both understood and complied with. Was that something you were aware of?
Again, not in those terms, but it must follow from the nature of the overall duty to the court.
Thank you. You were taken to the briefing note which reflected the clerk advice, which was annexed to it, which I think you were provided with in October 2013. I'm going to try and avoid going to it, but do you remember that set out that it considered Mr. Jenkins' failure to mention the second sight bugs, or the bugs that were mentioned in the interim report, in expert witness statements, breached his duty of expert disclosure? Do you remember that conclusion?
I have no independent recollection prior to reading the document, but upon rereading it, correct.
Thank you. And your evidence last week was that, to your mind, this was an historic issue, and you were given assurances by Cartwright King that the issue had been or was being addressed. Have I summarised that correctly?
No, I don't think you have summarised that correctly. I think when I arrived in the post office on October the 14th, I was given a large range of briefing material, very, very large range. The role of the General Counsel is very extensive and covered many areas. This was just a component part of that. This particular briefing I received on the 16th, I believe, of October, and my understanding from that was that this was background briefing. It wasn't. There was no further action to be taken, and that the action that did need to be taken was in relation to the so-called SIFT reviews, and that was put at the very centre of my attention upon receiving that briefing. So it wasn't that I received a briefing that nothing should be done. The opposite is true. I received, to the best of my recollection, no briefing at all in relation to any ongoing duty that the Post Office had in that regard.
So your view that it was an historic issue was your assumption on reading that briefing rather than being given express assurances?
Assumption would be putting it the wrong way around. It was a meeting. I think the briefings were designed to identify courses of action that I should take as the incoming interim General Counsel. This wasn't identified as an ongoing action.
In your witness statement, you indicate that in addition to the briefing pack, you were provided with Brian Altman KC's written advice dated the 15th of October 2013. Do you remember that?
Yes, I do, yes.
Do you recall that in the course of that advice, he comments, "I am not clear whether Mr. Jenkins was challenged about the non-disclosure to Post Office, and if so, what the explanation was for it?"
I'm not sure I recall that paragraph.
We can go to it. It's POL 00006581, please. It's paragraph 148 of that advice on page 47. Thank you. Does reading that paragraph jog your memory in that regard?
Sorry, is it paragraph 148 or 149?
It's the beginning of 148.
Yes, I can see that paragraph now.
And is that something you would have read in October 2013?
I can't say for sure that I read the entirety of the advice, but I'm sure that I would have looked at the advice and tried to pick out salient points that were required further action. Reading this now, I cannot see that there was that it would have immediately leapt off the page to me that there was an action buried in that paragraph.
To the extent that that paragraph makes clear that Mr. Jenkins, or at least to Mr. Altman's knowledge, Mr. Jenkins may not have been challenged or been able to give an explanation as to the alleged non-disclosure, did reading that advice prompt any concern on your part that Post Office needed to ascertain the circumstances in which Mr. Jenkins had been instructed, including obtaining an explanation for him as to the alleged non-disclosure?
I don't believe that that paragraph alone would have prompted that conclusion. As I said, it was upon joining, I received an enormous volume of background material in that context, as the role itself is extremely wide and covers many, many matters other than the matters that concern the inquiry today. I think that in that context, I believe I would have read that trying to understand. I would have imagined at the time I read this, my understanding of what had happened previously was relatively limited, and that I had a very imprecise understanding of all the events that had occurred prior to my arrival. So the answer to your question is I don't think that would have prompted a trigger to take any action.
Does it follow from your answer that whether from this advice or from an independent conclusion you were able to draw from all the material that had been brought to your attention, you did not feel prompted to ask any questions of Cartwright King or the lawyers at Post Office as to how Mr. Jenkins had been instructed, and specifically whether he had been instructed as to the expert duty of disclosure?
No, I don't believe that this paragraph or other matters would have prompted me to ask that question. However, I did ask, I believe, the question, on what basis was he tainted? And I recall my general understanding throughout my entire time at the Post Office was that he was tainted because he knew of two bugs in the system which he had failed to disclose. So I did clearly ask a question about why is it that he is tainted.
Can we please go to POL 001 55555, please? This is a note dated the 2nd of September of 2013. We now know that it was authored by Roderick Williams. If we can just go down to the bottom of that note, please. On the right-hand side, we see noted there the question, what were we doing to instruct GJ? From what we take from that means Gareth Jenkins. And on the left-hand side, a list under the words M. Smith. Don't think he's ever been advised of his duties. When you joined Post Office shortly after this note was written in September, did anyone share with you a knowledge or concern that Post Office had failed to instruct Mr. Jenkins properly, or that there was at the very least a serious question as to whether they had?
I have no recollection of that being shared at the time or shortly after joining.
Would you have expected that to be information that Mr. Williams ought to have shared with you, the concerns in this note?
Yes, indeed. I think the general structure of legal teams, in-house legal teams, general counsel's role, is it relies very much on a sort of a full and candid description of matters being disclosed to you by all members of the team, in a sense, without prompting. So I have no recollection of it. I don't believe that it was mentioned to me at all in those first few weeks at Poll or thereafter.
And do you agree that following that mission statement of full candour, that the potential failures acknowledged in this note, both in relation to their relevance to individual cases, but also because they may give rise to serious questions about the basic competency with which Post Office prosecutions were brought, were so serious that they ought to have been shared with Post Office's board, with Second Sight, with the mediation scheme, with Mr. Altman, and with the CCRC?
Yes, indeed, I do agree with that. If this had been made as clear as has been made in the course of the last few minutes in this questioning to anyone, I believe, in the legal team, that the next issue would be who knows how should what are the implications of this?
I'm grateful. If I may be permitted just to ask on one final topic, sir, I hope I can do it in about 2 minutes. Thank you. And it's just to follow up on some questions you've been asked about remote access and knowledge within the Post Office in 2014 as to Fujitsu's ability to insert transactions remotely and, crucially, in a manner which did not require the approval or consent of SPMs. If we can quickly please go to poll 001-08538. And the top of page 4, please. Thank you. This is an exchange between Mr. Williams and James Davidson of Fujitsu on the 14th of April of 2014. James, could Fujitsu please answer the questions below so that we can respond to a specific challenge put to us by Second Sight in connection with a mediation scheme complaint, namely that the Andy Wynne Alan Lusher email in the case of Ward, were you aware that that was a 2008 email that had been identified by Second Sight?
No, I don't believe I was.
That email explicitly states that Fujitsu can remotely change the figures in the branches without the SPM's knowledge or authority. And there follow a series of questions for Fujitsu. If we can then please go to the top of page 2. At question 2, Mr. Davidson is asked, can Fujitsu change branch transaction data without a sub-postmaster being aware of the change? And the answer comes, once created, branch transaction data cannot be changed. Only additional data can be inserted. If this is required, the additional transactions would be visible on the trading statements, but would not require acknowledgement or approval by a sub-postmaster. The approval is given by Post Office via the change process. Were you aware of this information being obtained from Fujitsu in April 2014?
I don't believe that I was copied in on that email chain, but I could be wrong. If I was, there was a subsequent chain which I was copied in on, which concludes with a question and the answer, and I comment on that in my witness statement. So I don't know if that is the same chain as this or not.
Certainly in this version of the chain, you're not copied in, although I think you are referred to. Can we please go to something you were aware of, which was the draft Project Zebra Deloitte report dated the 23rd of May 2014. That, you'll recall, led to the asking of 4 questions to Deloitte, the answers to which formed part of the board briefing dated the 4th of June of 2014. If we can perhaps go to that, please. It's poll 000-28069. And if we can go to page 8 of the document, although it's internal page 7, please, and the bottom of the page. Thank you. Under number 3, this document is dealing with the balancing transaction process. And it says, this is an emergency process accessible only to restricted individuals in Fujitsu, which can create transactions directly in branch ledgers. This process creates an identifiable transaction in the ledger, verbally asserted by poll staff to be visible to sub-postmasters in their branch reporting tool, but does not require positive acceptance or approval by the sub-postmaster. Do you agree that both of these documents from April and May 2014 clearly, of June 2014, clearly showed by then that it was explained to Post Office that a balancing transaction could be done by Fujitsu without requiring the approval or consent of a sub-postmaster?
Yes, I agree that this references the possibility in circumstances where there are individuals with the appropriate access right. Yes.
You were taken by my learned friend Mr. Maloney to a holding response that was sent to Second Sight in light of those James Davidson answers that were given in April 2014. And I think you'd agree that holding response made no mention of the fact that balancing transactions don't require approval or consent. Do you agree with that? In light of the limitations in that holding response, was that knowledge about balancing transactions and the lack of approval or consent by sub-postmasters shared by Post Office with Second Sight and the Mediation Scheme Working Group?
I don't believe it was, and I believe the reason for that is that it was, as I said earlier, perceived within Post Office that this was a very positive document. Indeed, there were proposals to publish it and make it widely available, which were unhappily not proceeded with due to restrictions imposed by, I believe, Deloitte. To answer that question precisely, it was known, but it was the understanding of the implications of this were quite different then to what they are today. And the reasons for that, I'm afraid, I just do not know.
Okay. Do you think it should have been shared at the time?
I believe, knowing what we now know about Horizon and the matters that have come to light, and with the benefit of hindsight, this document this particular finding should have been, yes, indeed.
I don't think you need hindsight, do you, Mr. Aujard, to be able to say that when Second Sight asked the Post Office a specific question which requires a clear and specific answer, they should be given it.
Yes, sir, that's correct. Sorry, I was referring more generally to the rest of the world.
All right. I think that concludes the questioning for you, does it not, Miss Oliver?
It does, and I'm sorry to have gone over time, sir. Thank you.
That's all right. So thank you for your very long witness statement, and thank you for attending twice to give evidence to the inquiry. I'm grateful to you. So, Mr. Stevens, shall we break off for our morning? And I think we better make it a 15-minute break now, given the events which have occurred.
Yes, sir, and then we'll hear from Mr. Smith.
Yeah, fine. So does that make us, what time should we start, 11:25?
Yeah, 11:25, sir, thank you.
Fine.
Good morning, sir. Can you see and hear me?
Yes, thank you.
Thank you. Mr. Smith has returned and will be with us for the rest of the day today.
Yes, of course.
Thank you. Mr. Smith, we left off yesterday after discussing the conversation you had with Jarnail Singh. I think you said you were in a car, pulled over to the side of the road.
Yes, I'd parked up at a suitable opportunity and then attempted to record the latter part of the conversation, given what Mr. Singh was telling me.
And you said record. Was that on your phone or?
It was using one mobile phone, my personal mobile phone, to record the conversation that was taking place on my work mobile phone.
Did you retain that recording?
I didn't retain it, no. It was removed from my personal mobile phone before I went abroad. I asked Cartwright King to remove it for me.
When you say you moved it onto a different device, or?
I left the IT department working out how to download it.
And are you aware of whether it was or wasn't downloaded?
I believe it was.
And if it's still held, will it be held by Cartwright King?
I have no idea whether it's still held, I'm afraid. I left Cartwright King some time ago.
Thank you. The inquiry will make inquiries about that recording. Can we please look at poll 001399747? I'm now moving on to Mr. Clark's advice that followed that phone call. If we could start by looking at the second page, please. We can see there Simon Clark is circulating a draft of his advice. If we scroll up, we can see that you are one of the recipients. I don't need to take you to it. You did respond to this with some typographical changes. Are you aware of having made any other?
I did respond to it, did I?
You did, yes. I mean, I can take you to it if you'd like to see it, but it was just typographical.
I don't recall making changes. But I don't dispute that if you say that I did respond to it, then I did.
Yes, for the record, it is poll 00327054, but we don't need to go to it. There's a response from Steve Gelsthorpe. Who was he?
He was one of the directors, one of the senior directors at Cartwright King.
And I'm going to read to you the second paragraph there. He says, I have seen Simon Clark's note. The comment I have is how we are going to impart the advice to the post office that if there are factions within it who are running around trying to lay off blame for their own shortcomings by lying about the advice they have received, then they lose privilege. I thought Simon Clark's advice would cover this. On reflection, it may be something for Andy to raise with Hugh and to note or to confirm in a letter to him. Can you assist us with what your understanding was at the time of factions within the post office?
I didn't fully understand that comment made by Steve Gelsthorpe. What I assumed he was referring to was the suggestion being made to Jarnail Singh that if anyone asked about the destruction of the minutes, i.e. the central record, they would say that that was the advice of Cartwright King. And of course, that wasn't the advice of Cartwright King. It was Cartwright King who advised that they should have a central record.
Was your understanding at the time of that conversation that Cartwright King were being intentionally blamed, or that somebody had misunderstood advice that Cartwright King had given?
I don't think it was a throwaway comment. I think it was a comment made that if an inquiry was made about why minutes had been destroyed, that is what would be said. That is why I was so concerned about what I'd heard.
Said in a threatening manner, or in...
Well, it was relayed to me by Mr. Singh. So I only had what Mr. Singh had said.
But did Mr. Singh say that he would tell somebody, or that Mr. Scott would tell somebody that Cartwright King had
it was Mr.
advised?
Singh who had reported to me what Mr. David Posnett had said.
Thank you. Well, let's have a look at the advice itself. It's poll 00006799. Thank you. And if we scroll down and over to page 2, please, we can have a summary of information that Mr. Clark says had been relayed to him. He says as follows: at some point following the conclusion of the third conference call, which I understand to have taken place on the morning of Wednesday, the 31st of July, it became unclear as to whether and to what extent material was either being retained centrally or disseminated. The following information has been relayed to me. 1. The minutes of a previous conference call had been typed and emailed to a number of persons, and instruction was then given that those emails and minutes should be and have been destroyed. The word shredded was conveyed to me. Where he says the following's been relayed to me, and he says they're conveyed to me, is that by you or by somebody else?
It would have been by me, because this is very soon after the conversation with Mr. Singh.
And I think yesterday you said you couldn't recall the exact words used.
I cannot recall the exact phraseology that Mr. Singh used. I cannot recall how he phrased it. I do recall being quite horrified, and as I say, recording the last part of the very last part of the conversation. And as a result of that, I recall travelling to Nottingham, playing it to Mr. Clark, and relaying my recollection of the conversation and the concerns which Mr. Singh had and which I had.
Yeah. Presumably it's quite unusual for you to have recorded a client.
Very unusual. I was so concerned about what I was being told here. That is why I used my other telephone to try and record this.
Were you concerned about the potential impact on Cartwright King and their reputation?
I was concerned that it wasn't the concern about Cartwright King. Well, I suppose I would have been concerned if people were going to make allegations against Cartwright King, but I was concerned that the head of security at Post Office Limited was allegedly suggesting that the central record be destroyed.
The second point there is handwritten minutes were not to be typed and should be forwarded to the Post Office head of security. Again, is that something that you would have relayed to Mr. Clark?
Yes, he wouldn't have known otherwise.
And the third, advice had been given to Post Office, which I report as relayed to me verbatim, and we see there the words used. Again, when he says relayed to me verbatim, is that by you?
I would expect so, yes.
And that is, in fact, very similar to the minute that we saw yesterday, isn't it? From Mr. Parsons.
Yes.
Was that your intention to convey the words that had been used by Mr. Parsons in that meeting?
I think this was a general conversation because I was unimpressed with how the approach to the Wednesday morning call was changing, and I was also concerned about the conversation I'd had with Mr. Singh. So this would have been a general conversation with Mr. Clark.
So the information you're providing Mr. Clark with is not just from that conversation you had with Mr. Singh, but also, for example, the information that you obtained on the 19th of July weekly meeting?
Well, what I discussed with Mr. Singh was my perception of how things were changing. So it wasn't just discussing the report that he had received from Mr. Posnett. I was discussing also with him how the landscape appeared to be changing, and I wasn't impressed by that.
And that's number 4. Some at the post office do not wish to minute the weekly conference calls. Who did you have in mind there?
I don't know if we ascribed any names to that.
Thinking back to the time, who might that have
Well, I do recall on the third call saying to Roderick Williams that it was necessary to maintain a central record. So I don't know whether I had him in mind at that particular point or other people, but I was quite clear on the third call that it was necessary to keep a central record. And then, of course, my subsequent call with Mr. Singh, I think, was either potentially later the same day. I think it could have been that evening.
Thank you. Let's have a look at the response from the Post Office to this advice. Can we please look at poll 00006797? I don't know if you saw the evidence of Mr. Williams or of Mrs. Crichton, where we discussed this document.
I haven't had time to watch this all the time.
So this is the response that is in Susan Crichton's name. I think Roderick Williams may have given evidence that he drafted it. I'm just going to read to you a few small passages. In the first paragraph, it refers to Mr. Clark's advice, and it says as follows: that advice was prepared as a consequence of statements purportedly made in connection with the weekly conference calls we established to share across Post Office Limited issues identified with the Horizon system. If we scroll down, we can see a paragraph there that says, Post Office Limited is committed to conducting its business in an open, transparent and lawful manner. Any suggestion to the contrary would not reflect Post Office Limited policy and would not be authorised or endorsed by Post Office Limited. Accordingly, the purported statements referred to in Simon's note do not reflect or represent Post Office Limited's position. Now, they're referred to there as purported. Was it your view that the information that had been conveyed in Mr. Clark's advice was simply purported or something that actually occurred?
I was under the impression that it had actually occurred. And now, if an instruction is sent out and emails have been sent out to numerous people, then obviously not necessarily everyone is going to react to them at the same time in the same way. But nevertheless, I was concerned that an instruction had been given and information had been destroyed.
The commitment there to openness, transparency, etc., does that reflect your understanding of the Post Office's approach at that point in time?
I think my view changed over time. There was certainly attempts to use legal privilege to cut down the amount of information which might otherwise enter the public arena. But at this very early stage, I was certainly of the view that there was going to be a single central hub of information which was going to be accurate, and I could understand the position that Post Office would wish to avoid from a publicity perspective and also a civil litigation perspective of potentially having incorrect information through supposition or guesswork entering into the public domain. So,
from your dealings with Mr. Singh at that time, Mr. Williams at that time, Mr. Scott at that time, do you think that the statement that's made there from the Post Office was an accurate one?
Not in relation to Mr. Scott, no, because why else ask for the or instruct that the minutes be destroyed?
Can we please move on to poll 003259492? And if we could please move on to the second page, the bottom of the second page, there's an email from Jarnail Singh to Mr. Scott and Mr. Parsons. And it relates to the weekly call. And it says, John/Andrew, I understand the remit of the above meeting was to establish a weekly conference call to act as a central hub for all Horizon-related issues. Attendees to bring all Horizon-related issues that they had encountered. Minutes were to be taken, centrally retained and disseminated to those who required the information. Most certainly, the Post Office's Horizon expert and QC would require this information. And then there's a list of various issues that had been raised at telephone conferences. And if we scroll down, there are a series of questions that are posed in Mr. Singh's email to Mr. Scott and Mr. Parsons. And he asks, who is retaining this information? Who is hunting down the issues? What has been the precise problem in each case? How was each case resolved? And the contact details of each attendee need to be circulated amongst the group. Now, first of all, does this sound to you like an email that was drafted by Jarnail Singh?
No.
Can you assist us with who might have drafted it? If we scroll up, we can see the recipients. Let me pose the question slightly differently then. Did Cartwright King draft emails that were sent by Jarnail Singh in his own name?
There were certainly cases where emails that had been sent to Jarnail Singh could have been or would have been cut and pasted by Mr. Singh. But I also had almost daily telephone calls with Mr. Singh and would explain my views on things or pose questions, and it was not uncommon for those then to appear in an email.
So is it possible that this email followed either a communication from yourself by writing or by a telephone call with yourself?
It is certainly possible that this email was sent by Mr. Singh following a conversation with me, because I think I would have been concerned to ensure that the minutes, the central record was being kept.
And it's sent to John Scott, but also to Andrew Parsons, and starts with saying John/Andrew. Is there by this stage a kind of turf warfare going on between Cartwright King and Bond Dickinson?
I don't regard it as turf warfare. I felt that Bond Dickinson were perhaps having too much control over Post Office, and that's what I said to Mr. Singh when I was in the car that particular evening when we discussed the instruction to destroy the minutes that had apparently been given, because my view was that we had as a firm advised very clearly that a central record had to be kept. That advice had been accepted by the legal team at Post Office. That advice was given by Simon Clark with myself present at a meeting in Old Street. Very soon after the second site interim report had been, I don't know if it's been published at that time, but we'd become aware of it certainly. But that information was imparted to Post Office. Post Office had accepted that and then set up the Wednesday morning call. And within a couple of those Wednesday morning calls, it's almost as though that requirement to keep a central record was being watered down. It was being, I took the view it was being overridden, if you like, by civil litigation objectives. Because at the very first Wednesday morning conference call, Mr. Parsons had been discussing and of course, I don't, as I've said yesterday, I don't agree with those minutes, and it's not a transcript either. But Mr. Parsons had explained from previous experience how it can generate nasty surprises when you have to do a trawl of emails across an organisation, and you can find out things that you don't know and find out things that are incorrect as well. And I didn't think from a criminal litigation point of view that that would be helpful either. So I could see that he was advising from a civil litigation point of view, but by the time we got to the third conference call and there was a suggestion that actually we're going to change the way we're doing this, and I can't remember that call, but there was definitely a suggestion of a change in the way that it was going to be approached. And I felt that that was effectively the influence of the civil lawyers.
If we scroll up, we can see the response from Mr. Parsons. In relation to the question, who is retaining this information, he says, minutes have been taken of each meeting along with action points. These have now been collated into the attached weekly report. If we scroll down, see what has been the precise problem in each case. And he says as follows: to the extent that details about a problem are known, these have been captured in the minutes. However, this will always be challenging because the discussions at the meetings can be quite fluid. Do you think that that was a full and accurate picture that's being painted there of recording problems? Do you think the fluidity of the meetings hampered the minuting of those problems?
I don't think the meetings were actually that fluid. I think the meetings were actually quite structured. At times there were issues hearing people because of dogs barking in the background or other noise. But certainly that didn't jump off the page at me at the time as anything to be concerned about.
But looking at this now, does it look to you to be a fair and accurate picture that's being painted there of...
Well, looking back at this now, I don't think the minutes were that accurate. I don't think I realised that at the time. Well, I didn't realise it at the time, because generally when minutes were circulated, I simply filed them with a view to taking the view that's the central record and will be instructing an expert in due course who can have access to those minutes.
Not accurate in the sense that there were typographical issues, or not accurate in the sense that they underplayed certain issues?
Not accurate in that they underplayed certain issues. And I came to that conclusion when I was drafting my second witness statement, because although I don't have the notes from those individual meetings, which I was taking myself, and as I said, I took quite detailed notes, I was able to compare the information that I think it was Mr. Bowyer had repeated in certain documents, and compare that against the minutes that had been provided. And I had more information than the minutes in certain circumstances.
Can we please look at poll 003236676? This is an email from yourself to Susan Crichton on the 19th of September 2013. And it also relates to the weekly calls. And you say as follows: Susan, many thanks for your email. I've been considering the position today, and I remain extremely nervous about having Fujitsu's lawyers on the Friday conference call. At the present time, only post office lawyers and lawyers instructed by the post office are on the call. If Fujitsu lawyers are on the call, they will have a duty to report the entire contents of the call back to their client. Whilst there may be merit in us meeting with Fujitsu lawyers if, for example, they are able to assist with disclosure, etc., I think that such meetings should be on an ad hoc basis and with very clear and limited agendas. With a conference call, there is, in my opinion, a greater risk that the Fujitsu lawyers may try to raise issues which we/you would prefer not to be discussed in front of them. In reality, was this a concern on your part that in fact Fujitsu lawyers would raise things at those meetings that you were concerned about being raised at those meetings?
No, I was actually concerned that Fujitsu's lawyers might try and, first of all, push the conversation in directions which were fitting their agenda rather than post officers. And quite frankly, I didn't trust them.
Were you not concerned that they might bring up issues such as the reliability of Gareth Jenkins within those meetings?
I have no doubt that that would have been probably brought up by Post Office Limited, but I didn't think that it was appropriate for Post Office Limited to discuss that with Fujitsu's lawyers at that stage. One of the concerns that I had was that I think I have an impression that in the case of Jishan Patel, which is a case we touched on yesterday, that I was told that that witness statement was coming to Cartwright King via the internal lawyers, via Fujitsu's lawyers. And of course, we know that that witness statement, or I seem to remember that that witness statement, only made reference to a single bug at Calendar Square in Falkirk. Now, of course, that is only one very small piece of the jigsaw puzzle. And of course, a lot more has come out since. But I was concerned about the involvement of Fujitsu lawyers at that stage.
Thank you. Mr. Smith, are we to understand from your evidence yesterday and your evidence this morning that you were in favour of things being recorded, that you were in favour of transparency, and that you, in your work for the Post Office, were not concerned about keeping things off the record?
I think generally the approach changed over time because Post Office were concerned about things unnecessarily going into the public domain. And so whilst we set out with the idea of making sure that everything was properly recorded, and I thought it was being properly recorded, in terms of transparency, I do realise that as time went on, Post Office had, if you like, a preference to avoid things going into the public domain unnecessarily, and that was pretty much driven by, I believe, the civil lawyers and Roderick Williams, who would say, well, this is a mediation case, or this is a group litigation case. Let's not make any unnecessary correspondence about this. I took the view that, well, they're the experts in civil litigation. I wasn't going to get involved with that. My concern was that there was a central record.
Do you think that over time you ultimately played a part in that lack of recording of issues to do with Horizon?
I can't think of playing the part of a lack of recording of issues.
Let's look at some documents from 2016. Can we please turn to Pol 001-39681? This is a meeting from the 23rd of March 2016. We see regular meetings in 2016. Are these now litigation meetings rather than the original weekly meetings?
No, they are if the 23rd of March 2016 was a Wednesday, that would have been one of the Wednesday conference calls. They were initially on a weekly basis, then they became bi-weekly at some point. But inevitably, there were references on some of these calls to the civil litigation that Post Office was being involved in. And I can recall Post Office wanting to be careful about, again, generating email traffic. I think at the time
I think you're anticipating the questions that I'm going to be asking.
Yeah.
So this was the weekly meeting.
Yes. Well, whether it was weekly or bi-weekly at that time, I don't know, I'm afraid. But it was the Wednesday.
Sorry, what was originally
Wednesday.
called the weekly
Yes.
meeting, yes. If we could have a look at page 2, please. We have an entry, if we scroll down from Andrew Wynne, and it refers to an issue in Wimbledon, Wimbledon 119001, I think, is that a branch number, possibly? It says unpaid checks, stock line on Horizon, branch challenged why a value showing £2,500 loss when removed, fault to be created on NBSC kit, to be corrected in the same way to see what effect this has. This theme may date back to 2005. AW, so Andy Wynne, to ask Wendy Mahoney to progress in his absence. And then it says this, MS, that's I think yourself, asked for assurance that there would have been no prosecution based on this type of incident. So there's an incident relating to a discrepancy in a Wimbledon branch, and you're asking if for assurance that there wouldn't have been a prosecution based on that type of incident.
Yes.
Yes. Could we turn to poll 0014004, 30th of March. This is the same issue, the Wimbledon transaction correction issue, and it's an email from yourself to Andrew Wynne. Andrew Wynne was one of our Phase 3 witnesses. He was in the product and branch accounting team, is that correct?
I couldn't tell you, I'm afraid. This is a long time ago.
Do you recall why you were contacting him specifically?
Well, I think that the issue having been raised on that call, I wanted to know more information because ultimately what I'm still trying to do here is make sure that we have visibility of what's happening and a central record.
And you say as follows, during the bi-weekly conference call on the 23rd of March 2016, you made reference to a branch at Wimbledon and explained that transaction corrections had been issued which should not have been issued and that they had accordingly been undone. You went on to explain that there was a risk that transaction corrections may have similarly been issued to other branches which may have caused losses, possibly going back as far as 2005. And then you set him a number of different questions, an explanation on the precise reason that the transaction corrections have been issued, the value, the effect, etc. 7 and 8, you ask whether this is an isolated incident or this is an issue which has or may have affected other branches, and 8, if this issue has affected other branches, the period of time over which transaction corrections may have been wrongly issued, and the names of the branches affected. So it's an issue that may go back to 2005. We're now in 2016. Can we please look at an initial response, which is at poll 00153939, 5th of April 2016. It's a response from Wendy Mahoney, case review team leader, and she says as follows. She says, I'm covering for Andy at the moment. Please find responses to the first 6 questions. Questions 7 and 8 will take slightly longer, as I will have to obtain information from different departments within the post office. If we scroll over the page, please, to page 2, we can see her initial responses. If we scroll down, question number 3, where you requested the effect of those transaction corrections on branch accounting, the response was it doubled up the discrepancy from £2,400 to £4,800. So quite significant information there about a bug that is doubling the discrepancy in the Wimbledon branch.
Yes.
And we see there 7 and 8 at that point had not yet been answered. We then go to the further response from Wendy Mahoney. That's at poll 00241095. 26th of April 2016. She says, "Hi Martin, FSC have now provided an update on questions 7 and 8. Please see narrative and table below. If you require any further information, please let me know." Now, it may be that you're not able to assist us with exactly what this all means, because it does look quite complicated, but the first paragraph says, "I've looked into the unpaid check GL for all items that have been posted since 2010. This resulted in 15,000 plus items." She says that they were looked at, but then she goes on to say, "However, system archiving at 13 months meant that a large number were unavailable to investigate." So there seemed to be some sort of time limitation on that investigation. Do you recall that at all?
I'm afraid I don't recall this, no.
She then says, "I then moved on to the actual transaction corrections that had been issued and read individually the text detailing the cause of the transaction correction. From this, I managed to pull out the details for the archived items. Results as below for all transaction corrections issues 2010 to current date." And then there's a table underneath, and it says, "Transaction corrections issued, not compensated, that feature the same issue as the Wimbledon list below." And there is a list of various branches that had been affected by this issue. Do you remember being concerned about this?
No, and I think this fell during a period just after I had left Cartwright King. If we can go back up to the top of the page, you'll see that the email that,
26th of April.
The one I sent initially was at the end of March, and I believe that I left Cartwright King at the end of March, which is, I think, one of the reasons why I copied in Simon Clark and Harry Bowyer, who were remaining at Cartwright King for a period of time. And then, at some later point, we commenced, or we certainly commenced working for Cartwright King on an agency basis. So I think this perhaps fell into a gap just after I'd left.
So when you say you left, you set up a company with Mr. Bowyer and Mr. Clark?
We did, and I remember that I left Cartwright King a month before they did. Oh, I believe that I left Cartwright King a month before they did. I think I left Cartwright King at the end of March.
Okay, well, we'll have a look and see what capacity you may have been in attending various meetings. But are you saying that you don't recall receiving this information?
I don't recall this information. I'm not saying that I haven't seen it at some point, but I don't recall that information. And it may be that be down to the fact that I left.
Well, let's look at the various meetings that you are present at throughout May, and we can try and work out in what capacity. Can we please look at poll 00120311? This is a meeting of the 4th of May, and it has you down there as Martin Smith of Cartwright King.
Yes.
Were you still at Cartwright King on the 4th of May?
So I wasn't an employee of Cartwright King on the 4th of May, but we were working on an agency basis for Cartwright King.
Were you still acting for the post office?
Cartwright King was still acting for the post office, yes.
Were you still acting for the post office?
Well, I was certainly attending these meetings. I don't know whether I had access to my emails at this point in time.
Were you still acting for the post office?
Well, yes.
Roderick Williams is down under legal as well. We see somebody called Shirley Hailstones under support services, if we have a look down. Thank you very much. Can we look on page 2, please? Under Wimbledon. SH, so Shirley Hailstones. Do you recall Shirley Hailstones at all?
I recognise the name.
seeking clarification of the figures, MS, which is yourself, saying that there was limited information available as data only presents for the last year and a half. See, that seems to be a recognition of some of the information in that previous email that referred to data only being held for 13 months.
Yes.
Do you recall being in possession of information about limited data being available?
Well, I must have seen some information, but how it came to me, I don't know.
The recent data suggests false balance issues, and therefore it will be useful to look into older data as well. SH asking who should make the decision about looking into older data. MS, that's yourself, saying that RW, I think that's Roderick Williams, could give the go-ahead. You will liaise directly with Mr. Williams outside of the meeting. It then says Mr. Williams is happy with this, but also emphasising that this matter is subject to the group action and data could be disclosable. Roderick Williams asking for no email traffic on this matter. Do you recall Mr. Williams saying no email traffic on this matter?
No, I don't.
Do you think that that was a proper request to make?
If his concern was to avoid emailing various different people and then incorrect speculation, then I could understand why he would want that in. But I was concerned that there was a central record. As far as I was concerned, this was now on the radar, and it would be open to an expert instructor to look into this.
And the concern there is that data could be disclosable, therefore no email traffic. Do you think that that is proper?
Again, that's civil litigation, and I took the view that that was Roderick Williams' domain and nothing for me to comment on.
Why were you at the meeting?
Well, this was a Wednesday meeting, so it was collecting information relating to the Horizon system.
Did you not have any views on whether or not there should be email traffic on a bug in the Wimbledon branch that's affected a number of different branches?
The issue had been flagged up, and there was information there.
Can we look at poll 000434335, meeting of the 18th of May? You're still present there, still referred to as Cartwright King, although, as you say, you may have been acting in your firm with the other two previous Cartwright King lawyers. If we scroll down, please, to the bottom of page 2. New issues identified. MS, that's your initials. Cartwright King. Issues, observations, comments. Wimbledon can be taken off this agenda. Martin and Roderick catching up offline. It looks very much like you followed Roderick's request not to correspond on that issue. Is that right?
It may be that it does look like that, yes. But again, as far as I was concerned, this issue had been flagged up and it was now in the central record. If Roderick Williams did not want additional material preparing from a civil litigation perspective, that was his call, not mine.
Mr. Smith, after all that you've been through, after all that we discussed yesterday, finding out about unreliability of Gareth Jenkins, finding out about bugs, errors and defects that hadn't been disclosed in criminal proceedings, proceedings that you were involved in, proceedings that led to the imprisonment of a sub-postmaster, finding out about a request from Mr. Scott to shred documents or destroy documents. Surely you couldn't have thought at this point in time that catching up offline about an issue relating to a bug was an appropriate action to take?
When it says offline, it's not offline completely. It's just simply not within this call.
Is that really your evidence?
Well,
There was a meeting, the previous meeting, where Mr. Williams asked for no email traffic.
yes. Well, at the end of the day, he is the client. He is saying, I do not want any email traffic. This has been flagged up. It is now in our database. It's now in the central record.
And you're having private meetings that no electronic record is being kept of.
Well, it wouldn't be in an email, but I would have had notes in my notebook.
So you were keeping a fully disclosable note of this issue.
I was keeping notes.
And were you providing that to the central hub?
No, they were my personal notes. I left the notes that I made at Cartwright King remained at Cartwright King. Now, this is after I left Cartwright King, but I was still keeping notes.
So what's the purpose of the central hub if you're keeping notes that are kept in your office that aren't in the central hub,
Well,
and that you're corresponding offline?
The central hub is to be able to provide information to anyone who needs it. My notes were an aide-memoire, so I could quickly look at things.
You were discussing a bug in Horizon that was affecting branches and causing discrepancies.
But it's been flagged up in the hub.
It's been flagged up, but the discussion about how long it's been going on for, whether it affects prosecutions, none of that's in the hub, is it?
Not on the basis of this record, no.
The answer to the questions you were asking earlier, does it affect prosecutions? It's being dealt with offline.
I don't believe that I thought of it in that way at the time, because the file review process had been completed. Disclosure had been made to those whom senior counsel had advised it be made to, and we had been informed that we did not need to go looking for cases prior to the 1st of October 2010. So this was something that had been flagged up. It was something that an expert could opine on in due course.
Can we please look at poll 00120321? This is a meeting of the 1st of June 2016. If we scroll over the page to page 2, now it says MC and RW agreeing this matter can be closed. On the minutes, MC seems to be Melanie Caulfield, who is in the communications team. Do you think that might be a typo and it might be your name, or do you think she, in fact, agreed with Mr. Williams that the matter could be closed?
I really don't know whether that's a typo or not.
Would it be odd if somebody from the communications team agreed that an issue relating to a bug could be closed?
I don't know if Mr. Williams had involved that lady in that discussion.
Can we please now turn back to a document that we saw at the very beginning of yesterday, and that's poll 004-11347. And that's the advice that you gave in the ongoing criminal matter of Zen Elvins. And could we please turn to page 3? This isn't 2016, this is 2015, but it's similarly late in the picture.
Yes.
And this is paragraph 9, so if we scroll up, where you advised that whilst this is not a Horizon issue, to the extent that the system permitted the sequences of transactions in accordance with its programming, it does not, of course, make the position any less embarrassing for Post Office Limited. There is, in my opinion, a substantial risk that any reports generated by a prosecution in this case may be utilised by those who seek to argue Horizon is defective or otherwise inadequate. By this stage, so 2015, going into 2016 and those meetings that we've been looking at, were you concerned about embarrassment being caused to your client, the post office?
I felt that it was our duty as instructed lawyers by them to flag it up.
Did you think perhaps that by 2016, when you were setting up a new firm, that it was important to keep the post office on side and to follow orders not to discuss things online?
I took the view that the civil lawyers would be making decisions in relation to civil litigation, and I didn't question their decisions.
Thank you. That can come down. I'm going to move on to a few miscellaneous topics before handing over to core participants. The first is remote access. I think we can take this relatively quickly because a number of witnesses have recently been looking at the same documents that we will be looking at. But can we start with poll 00141471? And we're going back in time now to November 2012. And could we start on page 4, please? At the bottom of page 4, we have an email from Rachel Panter to Gareth Jenkins, and she is seeking his report, Mr. Jenkins' report in the case of Kim Wiley, and it's urgent because the case has been listed. If we scroll up, there's a response from Mr. Jenkins. Paragraph 3, he says, reading through the defence statement, I see it does make some specific points which my statement doesn't currently address, specifically the challenges regarding robustness and remote access to the system. Do you want me to try and address the specifics? If we can go to page 3, Ms. Panter responds, copying you in, and she says, if you feel that you're able to deal with the issues of robustness and remote access fairly swiftly, then I would like you address these points that have been raised so that we can deal with every area that they have criticised. Can you assist us with why you're copied in? Were you supervising Rachel Panter or working with her on the case of Wiley?
I don't believe I was working with her on the case of Wiley. I think that was one that Mr. Bowyer was dealing with. Mr. Cash, of course, was the at that point the partner in charge of the Derby office and the partner in charge of the post office department.
If we scroll up to page 2, please, Mr. Jenkins responds. And he says, Rachel, what I propose adding is the following. I've been asked to provide a statement in the case of Kim Wiley. I understand that the integrity of the system has been questioned and that this report provides some general information regarding the integrity of Horizon. There's then a paragraph that addresses the integrity, and I want to look at the paragraph that addresses remote access. It says, I note a comment made about it being possible to remotely access the system. It is true that such access is possible. However, in an analysis of data audited by the system, it is possible to identify any data that has not been input directly by staff at branch. Any such change in data is very rare and will be authorised by the post office. As I have not had an opportunity to examine data related to this branch, I cannot categorically say that this has not happened in this case, but would suggest it highly unlikely. You, I think, have said in your witness statement that it's in a small font and you don't believe that you read the email.
I didn't read that in full at the time, no. And first of all, it wasn't a case that I was dealing with, and secondly, it was in a very small font, and I think it was also dealt with by Mr. Bowyer very quickly.
When you say it was dealt with very quickly, I mean, that ultimately ended up in the witness statement.
It did, but I think the response to Mr. Jenkins was very timely.
Let's move on to the Deloitte report. That's poll 000288062, 24th of May 2014. Page 31, please. I don't know if you were watching Mr. Aujard this morning, but this is a section I think that he was taken to.
I saw part of it from the waiting room.
Thank you. So it's the bottom of page 31, and there's various references there to the ability to insert what's called balancing transactions. A method for posting balancing transactions was observed from technical documentation, which allows for posting of additional transactions centrally without the requirement for these transactions to be accepted by sub-postmasters. And there are various concerns raised there about the controls that are in place to monitor that. We then have an advice written by Mr. Clark. That's poll 000217774. And this is an advice that has Mr. Clark's name at the end, 27th of March 2015. And he refers, if we scroll down, we can see there, paragraph 2, the reference there to parts of the Deloitte report. You've said that you don't recall this advice, but were you in any way assisting with the drafting of this advice?
It wasn't uncommon for Mr. Clark to run an advice past either myself or one of my colleagues to talk through it, to explain his methodology, his thought process. I may have seen it, I don't recall.
Often in his advice he writes, "we have seen," or "we have done this or that." Is that because he has discussed it internally?
I've never really given that any thought. It may just be his house style.
If we turn to page 2, there's reference to a telephone call with Roderick Williams and Andrew Parsons. We were informed that the Deloitte report was correct where it identifies a method of posting of balancing transactions. Were you part of that telephone conference?
I have no recollection of that, I couldn't say.
If we move on, please, to poll 000298867. 15th of July 2015, there's an email from Andrew Parsons. Now, it's to yourself and Simon Clark, and it relates to balancing transactions, so that is the ability to inject transaction data by support staff. And he says, "Martin, Simon, before Roderick went on holiday, he asked me to push forward the disclosure piece around balancing transactions. I understand that during the conference with Brian Altman, there was a discussion about doing some further investigations into when Post Office had used BT's balancing transactions on old Horizon, so that's what we know as legacy Horizon. As part of these investigations, we asked Fujitsu to explain how balancing transactions would work on old Horizon, and essentially it is possible to do the equivalent on legacy Horizon." He then says, "It has subsequently been confirmed by Fujitsu that searching for balancing transactions would in fact be an enormous task, taking several months of work." And he ends that paragraph by saying, "On this basis, the Post Office is not prepared to commission this exercise unless it is considered absolutely vital and there is no credible alternative." Now, given that you can't recall whether you're part of that earlier conference, that you can't recall the email from Gareth Jenkins that relates to his evidence on balancing transactions. Why do you think it is that Andrew Parsons names you as the primary recipient, the first named individual on this email in relation to the issue of balancing transactions?
Well, I may very well have been involved in the call. I just cannot remember it.
Might you have thought at the time that the ability to inject data by support staff was something quite significant?
I was under the impression that Mr. Clark was reviewing this and advising Post Office in relation to it, and I was letting him take the lead.
Why do you think Mr. Parsons is saying there Martin Simon? Why would he have the impression that you were at least jointly involved, if not the principal person to contact?
I was often the point of contact at Cartwright King, whether I dealt with something or not. And it wasn't uncommon for me to receive something and then pass it through to either Simon Clark or Harry Bowyer for their attention. And it may be that I was involved. I cannot recall.
By 2015, you were very experienced. It's not like you had to follow Mr. Clark in what he did.
By 2015, this had been going on for quite some time. It was virtually impossible to remember everything that had happened beforehand because this was a whirlwind. I certainly couldn't recall the issue with Mr. Jenkins talking about remote access arising at that earlier stage. That wasn't something that was springing to the front of my mind. It just simply wasn't on my radar.
Is there anything you recall about the Post Office's approach to remote access during this period?
I recall Mr. Clark advising that in order to determine whether or not it was going to be disclosable, further questions ought to be asked.
Did it cause you any concerns about all those cases that you have been prosecuting over the years?
Well, I don't think it did when I first became aware of the issue, because I didn't think that anything sinister would be happening. I mean, after all, this is the Post Office, this is Fujitsu. Why on earth would you think that things that were sinister would be happening?
I'm going to move on to the issue of Gareth Jenkins and expert evidence. You've addressed it in your statements.
Yes.
Were you aware throughout the period that we have discussed of the various requirements that are legally in place with regard to the instruction of expert witnesses?
I have to accept that I wasn't. Like I said yesterday, we had essentially been a defence firm of solicitors. We had presented cases in court on an agency basis, and as I pointed out yesterday, there is a world of difference between doing that and actually progressing prosecution files. Quite why Cartwright King thought it was appropriate to take on this prosecution work, I really, with hindsight, have no idea, because we certainly didn't have the training for it, and I was unaware of the duties on a prosecutor in relation to the instruction of an expert witness.
By 2012, you had been qualified for 16 years.
Yes.
Do you think it is unusual that you weren't aware of those kinds of duties?
I was simply just not aware of the duties on a prosecutor to actually make sure that an expert witness was fully informed of their duties, etc. It was clear from when Mr. Clark wrote his advice that we had been seeking reports from Mr. Jenkins in a way which perhaps was not, well, undoubtedly was not compliant.
Did you ever see formal written instructions to Mr. Jenkins?
By formal, in terms of a letter setting out all of that, no. Our approach had been that Mr. Jenkins had clearly been used as an expert witness in the past by the Post Office. Mr. Bowyer advised about the content of a generic expert report, if you like, that should be used as a baseline. And we then went from that point onwards, and no formal letters of instruction were provided.
Did you consider whether his witness statements complied with various legal requirements?
No, I don't believe I did. I took the view that we'd been advised to obtain a Section 9 statement, and that's what we prepared, and we sought to update it in cases in which there was a not guilty plea. I don't believe that I gave it any more thought than that.
At one point, you became involved in discussions relating to the instruction of a new expert or experts, Professor
Yes.
Kramer and Dr. Dooley.
Yes.
Can we please look at a few documents in relation to that matter? They can be found at Pol 00148-714. If we could start on page 3. How did you become involved in seeking out a new expert?
I think that probably came out of one of the very early conferences at Hull Street with Susan Crichton and others from the legal department after we'd become aware of the Second Sight interim report making reference to bugs. I don't think at that stage we necessarily knew about all of the information relating to those bugs. But Mr. Clark's view was that as they had not been mentioned by Mr. Jenkins, it could no longer be, Post Office could no longer rely on his evidence, and a new expert would be required. And I think, from memory, I think it was Susan Crichton asked us to see if we could find a new expert. And I think one of my colleagues actually prepared a short list of potential experts looking at various organisations around the country. But then ICL, I think, became the favourite.
Can we please scroll down to the bottom of this page? It's an email from yourself to Andy Parsons, the 9th of July 2014. And you say as follows: I would not advise that the experts be instructed to look at the old Horizon system. If the experts were to consider the old system, depending on their findings, disclosure issues could arise in historic cases. In any event, cases now being investigated and considered for prosecution will involve Horizon Online, which was rolled out during 2010. Can you please assist us with the first part of that response with regards to disclosure issues? What did you mean there?
Well, I think at that time we were being informed that the old legacy Horizon was no longer available in any way, shape or form to be tested, and important information relating to its design and functionality was no longer available. I couldn't see how any expert could actually then say, well, we've looked at the system and the system was fine. Any report that they would produce would have to be caveated incredibly. And then if there is a report that tells Post Office, I'm sorry, we cannot say anything about the legacy Horizon system, what sort of position does that put Post Office in? I was also aware that Simon Clark had advised that the experts should only consider Horizon Online, and I believe that Mr. Altman, King's Counsel, had advised similarly.
Mr. Smith, surely that second sentence relates to potential issues for cases that had been prosecuted if the experts were to find problems with old Horizon. Surely that's the only interpretation you can have of that second sentence.
I can see how it looks, But no, I was concerned that the experts would not be able to look at the system properly, and I could see that there could become all sorts of issues arising if they provided a report that basically said they could not, for reasons beyond their control, provide any certainty with regard to the old Horizon system.
Disclosure issues.
So if there was a report that was provided by Imperial College London which said that we cannot confirm that the old system was, and I'll use the phrase, robust, then that potentially would have implications in relation to every single prosecution.
If they didn't have enough information to say whether or not the system was robust because they didn't have access to the information because it was historic, you think that that could lead to problems with historic cases?
Well, yes.
Were you not more worried about the fact that they could investigate the old Horizon system and find a lot more bugs, errors and defects?
Well, I didn't think they could investigate the old Horizon system because it wasn't there to be investigated. It didn't exist any longer, and the information which related to it, I understand a lot of that key architecture information had gone. And I also understood that a lot of information related to historic prosecutions had gone through data retention policies.
If you thought that they couldn't investigate the system because the material wasn't available, it's a very odd way to start by saying if the experts were to consider the old system, isn't it?
Well, I think I would have read that as if the experts were asked to consider the old system.
Well, come on now. You're a lawyer writing to a number of other lawyers, and I think I can reasonably infer that you would write reasonably precisely in these circumstances. So why are you beginning this sentence on the premise that there could be a consideration of the old system?
Well, there could be a consideration to some limited degree, but it would be very limited.
You're adding words, Mr. Smith.
Sorry?
Those words don't appear at all in this email. Why should I assume or decide that you wrote an email which had more or less a completely different meaning from the one which is obvious reading this?
Well, I don't think it is different. I mean, there would be disclosure issues which could arise, but in any event, we were now looking at the new system, and Counsel had advised that we did not need to go looking for cases prior to 2010.
All right.
That was Mr. Altman Casey's clear advice that Post Office did not need to go looking for cases prior to the 1st of January 2010. And in those circumstances, I could not see any merit in asking an expert at considerable expense, contrary to the advice of Simon Clark, which was to focus simply on Horizon Online, why we would ask the experts to look at a partial amount of documentation relating to its design and no ability to actually test the system. I could not see that sort of report would be helpful at all, and could see that would be a nightmare situation.
Okay, I'll move on to the issue of disclosure post-conviction. We've heard a lot of evidence from you about, we spent a lot of time on the disclosure during, for example, Mr. Ishak's trial and during the trial process, but I want to move on to disclosure post-conviction. Can we please look at poll 00006581? And the issue is disclosure during the mediation scheme and to second sight. And this document that I'm taking you to is the Altman General Review. It's the 15th of October 2013. Can we have a look, please, at page 42? Mr. Altman records as follows in his advice. He says, during the telephone conference of the 4th of October 2013, the main topic of discussion was the extent to which Cartwright King should be involved in exercising a supervisory function over the criminal cases going to mediation, such as Mrs. Misra's case. There is understandable concern that offenders might use the mediation scheme to gain information as a platform from which to launch a fresh or new appeal. And so Cartwright King wished to exercise a measure of control over the dissemination of information and material during the process. Were you part of that telephone conference on the 4th of October 2013?
I cannot recall. I may have been. During this period of time, there were numerous telephone calls on different days.
And there seems to be a concern from Cartwright King as to cases that they had been prosecuting and potential disclosure to those who they had been prosecuted. Do you recall conversations of that nature?
I don't agree with the way that that's phrased, if I may say. I can recall that when the mediation scheme was started, it was not ourselves that were raising concern. It was Post Office that was initially raising concern that concessions could be made or throwaway comments could be made which might provide a mediation scheme applicant with some form of ammunition to argue that, for example, the case being presented by Post Office at that stage was different to the basis upon which they had been prosecuted, whether that had been by Cartwright King or indeed by the Royal Mail Group sometime previously. So I think it was initially Post Office that were concerned about the convicted applicants in the mediation scheme and the information provided to them. I think that's where the concern.
So you think that is wrong there, if it is to be read as suggesting that Cartwright King were concerned about people that they had prosecuted launching a fresh or new appeal?
I don't think it's a case of Cartwright King being concerned about the people that they had prosecuted. As I say, the concern was initially by Post Office in relation to blanket convicted applicants to the mediation scheme, irrespective of whom they've been prosecuted by. And I understood that Mr. Bowyer and Mr. Clark were able to understand that concern, and in fact, I think Mr. Clark advised in relation to it.
Why Mr. Bowyer and Mr. Clark? I mean, were you not a 3?
We were a 3, but the general way that we dealt with this was to have advice being provided by senior counsel.
You often,
Post Office was...
throughout your evidence, have been referring to Mr. Clark as being senior or more experienced than you. All of the emails that we've seen, there isn't a single one there that seems to distinguish in your seniority or abilities.
No, I was generally the main point of contact, but I have seen in the papers that have been provided, and I'm sure you will have seen them, there is evidence of me forwarding things to Mr. Bowyer to look at. There's evidence for me forwarding things to Mr. Clark to look at. I was the point of contact, and indeed in relation to the mediation scheme, I think it was agreed that there should be one point of contact at Cartwright King for all of the traffic to go through, and one point of contact at, I don't know if it was Bond Dickinson or Womble Bond Dickinson at that time, but one point of contact there. So that way it would keep lines of communication clear rather than different emails being sent to different people.
And that one point of contact was yourself?
And the one point of contact was myself at Cartwright King for virtually everything, irrespective of what it was.
So in that case, it's highly likely that the telephone conference that took place on the 4th of October involved yourself?
It may well have done. I can't remember it.
Can we please turn to poll 001688949? And can we start at page 2, please? This is the case of Noel Thomas that's being looked at. We've heard from Mr. Thomas. He was sentenced to 9 months imprisonment. His case is being looked at in May 2014. You were sent post office investigation reports, which in turn would be sent to Second Sight. And there's an email here from yourself to Andrew Parsons. And you say as follows: whilst we have advised that as a matter of principle, investigation and offender type reports should not be disclosed, I understand that there will be circumstances in which it is felt that there is no alternative other than to disclose these. In such circumstances, they should be appropriately redacted. If you would like me to deal with that, please let me know. So was it your view, as at May 2014, that the investigation or offender reports into those who have been convicted, like Mr. Thomas, shouldn't be disclosed as a matter of principle?
That was the advice that I received within Cartwright King, yes.
When you say that was the advice you received within Cartwright King, Mr. Smith, you are a lawyer from Cartwright
yes.
King. You are communicating with the client, Andrew Parsons. That is surely your advice.
It is also my advice, but that was the strong views of Mr. Bowyer and Mr. Clark, and I accepted that. And
Mr. Smith, you weren't on work experience with Mr. Clark.
No, I wasn't, but I was aware that they had a substantial amount of experience of prosecution cases, far more than I did, and I was content to follow their lead.
If we turn over to page 1, please. Mr. Parsons says at the bottom of page 1, thanks, if you could mark on the docs any bits that you would prefer to be redacted, that would be great. And you respond on the top email. You say as follows: Andy, please find attached the investigation reports on which I have highlighted in black the parts which I would advise be redacted. Consequently, I have also further amended the draft report in light of the redactions. I'm just noting here it's several I's so that there's no we.
No, it's not we, it's I, yes.
I would prefer not to let the applicant see the sentence in Diane Matthews' report of 25th of October 2005, which notes that she was currently awaiting the results of the tests by Fujitsu on the Horizon system. If those test results cannot be found, such a sentence may well invite a request for disclosure of the test results. There may also be a risk that the applicant will suggest that the investigation was inadequate or incomplete. Similar issues could arise out of the comment on page 7 of the draft report. However, it appears that the kit was taken by Fujitsu to allow the equipment testing to be undertaken. No documentation is available in relation to this. On what possible basis could those redactions be justified?
I really don't know. Looking at this with hindsight, I don't know.
I don't think you need hindsight to reflect on this. Perhaps on reflection.
On reflection, I was of the view that information which might put into the public arena the sorts of investigation work carried out by Post Office or sensitive methods or opinions should not be disclosed.
What's sensitive here? What you're saying here is that they should be redacted because they may lead to disclosure requests. What's wrong with disclosure requests being made by those who are convicted of criminal offences, some of whom were sent to prison?
Yes, I clearly got that wrong. I mean, as a firm, we took the view that anything which contained the opinion of, for example, an investigating officer about a witness or something about a method of investigation or something sensitive should be redacted. But I cannot see here, on reflection, anything which sensibly should have been redacted.
Wasn't it part of a culture of withholding information from applicants?
Not intentionally, no.
Can we please look at poll 00325867? It's the bottom email from Mr. Parsons to Chris Aujard, Roderick Williams, a team at the Post Office, copied to Simon Clark and yourself. He says as follows: I've just spoken with Cartwright King about the new, that's a questionnaire from Howe & Co. that references the Helen Rose report. So these are questionnaires that are filled out by applicants to the mediation scheme.
Right.
You will recall that the Helen Rose report was retrospectively disclosed in a number of prosecution cases as it drew into question some of the statements made by the Post Office's expert witness, Gareth Jenkins. A copy of the Helen Rose report has made its way to Howe, who are now referencing it generally in their questionnaires. For example, the questionnaire in MO60 refers to the Helen Rose report. However, the Helen Rose report was not sent to this applicant. The point of concern is that the MO60 questionnaire is starting to make the link between, one, the fact that the Helen Rose report makes clear that Gareth Jenkins knew of issues with Horizon, and two, the fact that Gareth Jenkins never mentioned these issues in his prosecution evidence. See para 53 in the attached. This line of inquiry draws into question the credibility of Gareth Jenkins's evidence. And that's precisely the concern that was raised in Mr. Clark's advice a year before that, isn't it?
It is.
It then says, the sharing of the Helen Rose report between applicants is potentially a breach of solicitors' ethics / contempt of court. However, Cartwright King and I don't believe attacking the solicitors on this point would be of benefit. If anything, it may draw more attention to the Helen Rose report. Instead, our preferred approach is to try and downplay the importance of the Helen Rose report in any Post Office investigation reports. We recommend minimising or ignoring entirely the Helen Rose report when responding to questionnaires. If the investigation team need guidance on how to address any Helen Rose report related questions, I suggest they or the lawyer here at Bond Dickinson addresses these directly with Cartwright King on a case-by-case basis. Please let me know if you're happy with this proposed approach. Martin, Simon and I are available if you have any questions. Do you consider that to be an appropriate approach to the mediation?
The lawyers at Bond Dickinson were advising Post Office in relation to the mediation. How they wished to deal with individual mediation applicants was a matter for them.
Why is your name on this email?
It's been sent through to us.
Why does it say Martin, Simon and I are available? Is Mr. Parsons entirely wrong? This is a Bond Dickinson affair, not involving yourself.
No, we looked at proposed responses to mediation applicants. That was Cartwright King's role, and as it points out here, the Helen Rose report started to become mentioned by other applicants. Post Office clearly didn't wish to explore that with a number of applicants, but that was their decision. We were not advising Post Office how to conduct the mediation process, and that was, in my understanding, was a matter for Bond Dickinson.
Mr. Smith, you had been advising the Post Office for years. We saw yesterday the proposed response to the CCRC, who were interested in matters after the second site report. We've seen in various places that crucial link between the Helen Rose report, Gareth Jenkins' evidence, the fact that Gareth Jenkins didn't mention certain things in his prosecution evidence. That crucial link has not been mentioned by the Post Office. And here there is discussion involving you as a key contact seeking to downplay the importance of the Helen Rose report, recommending minimising or ignoring entirely the Helen Rose report when responding to questionnaires. Do you think that that was appropriate?
I'm not aware that Cartwright King were involved in downplaying that.
Did you respond to this email saying that is grossly inappropriate, we want nothing to do with it?
I don't believe I did. I don't recall this email.
Did you respond to this email noting that your name had been mentioned in that final paragraph as a key contact and saying that I'm nothing to do with this?
No.
You don't remember receiving this email. Do you remember the issue being discussed?
Not this specific issue, no.
If we scroll up, you're one of the copy recipients. He says, I've just spoken to Cartwright King. Not you?
I don't recall this. I'm sorry, it's a long time ago. I just simply do not recall this.
So I think that might be an appropriate time to break. I'm glad to report that I only have about 15 minutes left after lunch, and then we can move on to the core participants who have all been given allocated times.
Jolly good. Then what time shall we start?
Can we start at 1:55, please?
Yeah, by all means.
Thank you very much. Good afternoon, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you very much. Mr. Smith, I'm going to now take you to advice that was written by Simon Clarke. Can we please... Actually, sorry, before I get to that, you mentioned before lunch your move from Cartwright King to your own firm.
Yes.
We have email correspondence from yourself in 2019 from a Cartwright King address.
Yes.
Are we right in understanding that you continue to be able to use the Cartwright King email address?
That's correct. I believe that I left... Again, I can't be specific, but I believe that I left Cartwright King at the end of March of 2016. I believe Simon Clarke and Harry Bowyer remained on for a little while. And at some point, I believe after they left, we then had access to the case management system used by Cartwright King in order that we could continue to work on an agency basis for them. And so we had email accounts, Cartwright King email accounts that we could use.
Thank you. Can we look at poll 00148720? And this is an advice on criminal applicants to the mediation scheme, the 15th of July 2014. It's another one of those advices that is written, has Simon Clarke's name at the end, 15th of July. But throughout the advice, if we scroll down to paragraph 2, for example, it says, "It is our considered view." And we see often throughout references to we. Did you have any involvement in this advice?
I'm afraid my answer has to be the same as the earlier ones. I may have seen it, I may have commented on it, I may have been asked to proofread it. I cannot state specifically that I had positive input into it.
And paragraph 2 says, "It is our considered view that no applicant guilty of a criminal offence committed against the Post Office should be allowed into the scheme. For to mediate such applications will be to leave the Post Office open to a number of alarming consequences. Those consequences include, but are not limited to, the following. The fact of entry into the scheme of itself indicates that the Post Office is at least prepared to concede that they may have erred in prosecuting the applicant. Similarly, the fact that one such applicant has been allowed to enter into a scheme sets an unfortunate precedent." It then goes on, subparagraph 3, about the threat of an appeal. Same paragraph 4. Setting a precedent, any competent lawyer would advise a substantial concession by the Post Office. And then paragraph 3 goes on to address other risks. It says, for example, whilst the issue is strictly outside of our criminal purview, we feel bound to point out that the potential for adverse publicity generated by the mediating of criminal applications, and particularly where some concession agreement or payment is made by the Post Office, is inestimable. It refers to the knock-on effect. There's every likelihood that we would be required to disclose the fact and detail to others in a similar position. Similarly, a successful appeal would give rise to a considerable assessment and disclosure exercise, all conducted in the full view of the media. Over the page, please. Paragraph 5, "We can identify no proper reason for the inclusion of criminal applicants into the scheme." Were those all views that you shared at the time?
I think I accepted that as being a sensible approach.
Can we please turn to poll 00112928, page 78. So that advice that we've just seen was July. We're now in November 2014. And it's an email from yourself to Mr. Parsons. You say, Andy, from a criminal perspective, we would advise as a general rule against the disclosure of any documents from a criminal file which have not previously been disclosed to the defendant during the course of the original proceedings. To do otherwise may well enable the defendant or second sight to attempt to criticise the way in which the prosecution was conducted or how the prosecution policy was applied. Clearly, such arguments in a public arena would be uncomfortable for the Post Office. We remain concerned that second sight are pushing for the disclosure of files and advise that a robust stance be taken by the Post Office in relation to all such requests. So you were concerned there about defendants being given documents that weren't relied upon in their criminal prosecution.
We are advising, as a general rule, against the disclosure of documents which have not previously been disclosed.
And is that because you were concerned about your own decisions coming under scrutiny?
No. No.
If you had made the right decisions regarding disclosure in the original trial, why would you be concerned about access to those files and disclosure from those files?
I don't think that it occurred to us that any incorrect disclosure decisions had been made at the time.
So why would you be concerned about disclosing documents from the criminal file if you had made the right decisions?
No, so the approach that Cartwright King was taking here was that if something was on a sensitive material schedule, then it ought not to be disclosed unless it was something that had been disclosed during the original proceedings.
Yes, and is that because you were concerned about the disclosure decisions that had been made in those original proceedings?
No, no.
We looked at the case of Ishak yesterday, and I think I suggested that you were perhaps taking too robust a stance on disclosure to Mr. Ishak. We see here another reference to a robust stance to be taken in respect of disclosure decisions. Were you now repeating the same errors that occurred during the criminal trials, that you were taking too robust a stance on disclosure to those who had been affected?
I didn't see it that way at the time.
Why do you think it was that after all that we've been discussing, and I won't repeat the various stages, Gareth Jenkins, new information, etc., why do you think then you were still calling for a robust stance to be taken in respect of disclosure to those who had been prosecuted?
Of course, this is in the mediation scheme, and the view that the firm was taking was that only material which would have been disclosed during the initial proceedings should be disclosed. I didn't disagree with that approach.
Yes, but that's really repeating the same point that you've already been making.
But that's my point. That's the point I can make. I didn't see it any other way.
And it isn't your evidence that you're concerned that in some way that would help somebody appeal?
No, I didn't think of that.
Can we please look at poll 00150-342? The bottom of the first page, Roderick Williams confirms there that Mr. Altman, Brian's advice is that we shouldn't engage with either of Tony, that's Sir Anthony Hooper's proposals, given the inherent risks in having a free discussion about the facts which give rise to a conviction. Do you recall Sir Anthony Hooper being in favour of including those who had been convicted, and Cartwright King and Mr. Altman forming the view that they shouldn't be?
I can recall Mr. Hooper taking the view that it should include everyone, and Brian Altman having a strong view about that, yes.
If we scroll up to the middle email, there's an email from Roderick Williams to yourself. He says, Martin, can you please give Chris Aujard a call as soon as possible. He wants to discuss how to approach Tony Hooper about mediating criminal cases, specifically those involving false accounting. Tony is not currently sympathetic to our position, so we need to work out how else we can land the points. And there is a response above from Chris Aujard, who says, thanks, Rod, we've now spoken, and the work that we discussed has been commissioned. Cheers, Chris. If we please could turn to poll 001503990, there is the advice, which contains a draft letter to Sir Anthony Hooper. Is that the work that had been commissioned, or was the work that had been commissioned something else?
I don't recall, but I can see that the advice starts here that we are asked to suggest the text of a letter to Sir Anthony Hooper.
Yeah, so
it may very well be that that advice is in response to the request that has been received from the then General Counsel.
do you recall having a conversation with Chris Aujard about this issue?
I'm afraid I don't.
Were you involved in the drafting of this advice?
It's possible that I may have seen it, been asked to look at it, might have discussed it. I don't recall.
What do you think made the team at Cartwright King, including yourself, think that you knew better than Sir Anthony Hooper on matters relating to those who are convicted of criminal offences?
I don't recall thinking about whether or not we knew better than Sir Anthony Hooper at all. That wasn't my thought process.
And I think you've said that your thought process didn't involve any consideration to the effect that you wanted to prevent people from appealing to the Court of Appeal.
No, the way that I had seen this was how it had initially been put by Post Office, that they were concerned, for example, that a throwaway comment or something like that, or some attempt to reach settlement might somehow give a convicted applicant a ticket to the Court of Appeal, just inadvertently through making some form of minor concession or presenting something in a different way. So I didn't see this as trying to prevent people from appealing. I saw this as effectively trying to help Post Office protect their position.
Mr. Smith, you've used the word ticket to the Court of Appeal. Is that because you have in mind the next document that I'm going to take you to, which is poll 000666872? And this is a file note from your file, May 2015, relating to Sema Misra's case.
Yes. Ticket to the Court of Appeal was a phrase which we used internally on a number of occasions.
Can you assist us with this note? It says, there's a summary, Andy Parsons, MJS, that's yourself, explaining position, issue redisclosure. Detail, telephone call, Andy Parsons, MJS explaining position, issues redisclosure. Clearly unhelpful if the Post Office proceeds with draft CRR responses. Those are, I think, case review report responses. Without regard to disclosure issues, may damage the Post Office's integrity. Disclosure may give Misra tickets to the Court of Appeal. Need meeting possibly of Thursday. Any chance can keep moving with the reports being watered down. You would not advise that. The problem will arise if you need to make disclosure and did not set the record straight when had the opportunity to. Also, there is the Criminal Cases Review Commission in the background. Were you and Mr. Parsons in May 2015 concerned about disclosure to Sema Misra because it may give her a ticket to the Court of Appeal?
No. I can't quite remember the timeline, but when we started the file review process, Mrs. Misra's case was one of those which we reviewed, but we were only able to review it from a very limited amount of information. I don't think the legal department could find the file at that point. At some point, the file did become available. Now, I don't know how that fits into this timescale, but at this point, Bond Dickinson were wanting to push ahead with responses in the mediation scheme. I assume that there was some sort of time frame within which they were trying to work, some sort of agreed time frame. They were wanting to draft responses, and I took the view that it's unhelpful to draft those responses without having regard to any potential disclosure issues, because if those responses are inappropriate, either because something needed to be disclosed which wasn't, or alternatively some sort of comment was made which was by way of concession, but an inappropriate concession, either way that could be damaging to Post Offices Limited's integrity. I was very aware that whatever was said in their CRR response could give any applicant the opportunity to approach the Court of Appeal. You'll see from the second paragraph here, the question I am being asked by Mr. Parsons is there any chance we can keep moving on these CRRs with them watered down? In other words, rather than wait for perhaps Simon Clark or Harry Bowyer to have finished a review of the case or some information, can they just proceed with that response watered down? I was against that, because I took the view that if they did so and disclosure was appropriate and it hadn't been included, then that would be damaging. If disclosure should have been provided and wasn't, there would be adverse consequences for that if the record was not set straight when Post Office Limited had the opportunity to do so. And I was also telling them, look, the CCRC are watching you. They are in the background watching what you do here. So I was very aware that the response to the CRR was something which had to be got right. And I wasn't prepared to allow Bond Dickinson to water this down. I was very aware that if disclosure needed to be provided, then it should be provided when there was the opportunity to do so. Otherwise, I could see there being all manner of repercussions for Post Office Limited.
It might be suggested that the reference in that first paragraph to disclosure giving Sema Misra a ticket to the Court of Appeal is that you were concerned, together with Mr. Parsons, about Mrs. Misra being able to successfully appeal in the Court of Appeal.
If someone could appeal, then so be it.
Was there a concern at Cartwright King, and a concern held by you and others, that there may be successful appeals to the Court of Appeal in cases that you prosecuted?
No, I wasn't concerned that there would be successful appeals at all to the Court of Appeal. That wasn't something that concerned me. My concern was that Post Office, in embarking upon this mediation scheme, should not be making small concessions which appear trivial but could actually be presented in a very different way, which could actually then give someone the opportunity to pursue an appeal. What we were seeing during some of these mediations were that some convicted applicants were actually putting forwards very different facts to the actual information that they'd relied on, for example, by way of mitigation following a guilty plea. So we were alive to some of these points. But no, in relation to Mrs. Misra's case, as it says in my second paragraph here, I would not advise proceeding with a CRR watered down. A problem would arise if disclosure needs to be made and we did not set the record straight when we had the opportunity to do so. It was important that it was correct.
Given everything that you had learned over all of those years that we've been discussing in your evidence, all of those various developments year after year after year, by 2015, didn't you think that you should do everything you possibly could for somebody like Sema Misra in relation to a potential appeal to the Court of Appeal?
Well, at this point in time, her file, I believe at this point in time, her file had been reviewed. I think the initial review was on the basis of, I think, just the judges summing up to the jury, but the file subsequently became available, and that was reviewed, I believe, by Mr. Cluck. And I'm unable to recall, actually, whether disclosure was sent through to her of the second site report and the Helen Rose report. I'm afraid I can't remember that.
Issues with Gareth Jenkins?
There was no reference to that in the letters which were sent out.
Various additional bugs, errors and defects?
Again, there was no consideration of disclosing that. The second site interim report made reference to 2 bugs, and we had the Helen Rose report. We were then really looking forwards and gathering information ready for the instruction of an expert.
Thank you. So those are all of my questions for Mr. Smith. We have a number of questions from core participants. The first on the list is Ms. Watt, on behalf of the NFSP, who will be principally asking questions relating to the Scottish cases.
And as I understand it, Ms. Watt has a 15-minute allocation. Is that correct?
Yes, that's correct.
Fine. Thank you. Over to you, Ms. Scott. Ms. Watt, sorry.
Thank you, sir. Good afternoon, Mr. Smith. I think I'm just behind Mr. Steve.
I can just about see you, yes.
Thank you. You can see me. I want to ask you some questions about the period in 2013 when you're dealing with what's happening in the Scottish prosecutions. And I'm not going to take you to a witness statement, but at paragraphs 132 to 134 of your witness statement, you refer to 2 meetings in Scotland in September and October 2013, which you attend with Simon Clark and Jarnell Singh, together with the Post Office's Scottish solicitors, where you say you met the Procurator Fiscal. And you say those meetings arose because there was a concern that there was to be a termination of Scottish criminal cases on the basis that Horizon was allegedly unreliable.
Yes.
Okay? Now, by this time in 2013, it's correct to say, isn't it, that you knew Gareth Jenkins had been discredited as an expert witness?
Yes.
Not least because your colleague Simon Clark had written advice for the Post Office about the issues with and the use of Mr. Jenkins as an expert witness. Isn't that right?
That's right.
And at that time, you also knew of at least 2 bugs in the Horizon system, didn't you, from the Simon Clark advice and the second site interim report?
Yes.
And while your interpretation of the second site interim report is not much to see here, you would agree that, in fact, it did raise questions about Horizon and a lack of disclosure to sub-postmasters in their defence at criminal prosecutions.
Yes.
You also knew what was in the Helen Rose report, didn't you?
Yes, I believe that's right at that time.
And you knew by the time of the meeting in September 2013 with the Procurator Fiscal that prosecutions in England had been paused by Susan Crichton because of all of these concerns, didn't you?
New prosecutions had been stopped, and existing prosecutions were being looked at on a case-by-case basis by Mr. Clark, I believe.
But nonetheless, you went to Scotland with your colleague Simon Clark and Jarnell Singh from the Post Office to try to prevent the Crown Office and Procurator Fiscal Service from terminating criminal prosecutions on the basis that the Crown Office was questioning the reliability of Horizon evidence for Scottish prosecutions, didn't you?
Well, we were asked to go, I believe by Susan Crichton, and there was a suggestion that the Procurator Fiscal was considering terminating all of the prosecutions. The suggestion that I believe Mr. Clark made was that they be adjourned pending a new expert, and the Procurator Fiscal's office was actually content to adjourn those cases to await a new expert. It was actually quite surprising because in England and Wales, it's unlikely a court would have entertained an adjournment of several months to get a new expert. So the position in Scotland, I understand, was quite different.
Well, I think it was explained to you why that was. I'm going to take you to some documents that might help with that. First of all, can we go to Paul 00139902? That's a telephone note from the 12th of July 2013, and you're on a call with a representative of the Crown Office.
Yes.
And this is you, sorry, I'm just, go to the correct one for me. 29th July 2013. And this is you on a conference call with a representative of the Crown Office and along with one other from Cartwright King. Would that be Simon Clark?
It could be.
You explained that your law firm carried out prosecutions on behalf of the Post Office south of the border, that you had been told the Horizon Horizon system was foolproof, but a report has been prepared by a body called Second Sight, which has revealed some bugs in the system. There's a second report, which the Post Office, are calling the Helen Rose report. It's an internal report and it's critical of the system. There are times when the system does not differentiate between computer-generated entries and manual entries. If we go on to the paragraph, Martin explained that Second Sight was basically a committee set up in response to complaints by some sub-postmasters. The Post Office contracted with Second Sight to produce this report following complaints made by sub-postmasters to various MPs. Would you accept calling it a committee set up in response to complaints by some sub-postmasters actually a minimisation of what Second Sight was and what you already knew it was uncovering?
I don't recall using those words.
It is a minimisation, isn't it?
Well, Second Sight is not a committee. Second Sight was a limited company, and it wasn't a committee set up in response to complaints. Second Sight was engaged to look into issues that had arisen. So I think that part of the notes of the conversation is incorrect.
You go on, the paragraph that starts, a number of defendants have had inexplicable losses, that paragraph. Martin explained that in some cases the Post Office, they've lodged expert evidence which said there was nothing wrong with the Horizon system. This expert was a man named Gareth Jenkins, one of the architects of the system from Fujitsu. It's clear from the report that Gareth Jenkins, employed by Fujitsu, was aware of bugs in the system. One in particular has created false information, but this was not mentioned in his reports. Would you agree that, taking account of the Simon Clark advice and all that was known by that time in relation to Mr. Jenkins, that is a minimisation to the Crown Office of the position?
No, I don't. I think that sets out the position. Mr. Gareth Jenkins, one of the architects of the system, it's just moved on my screen. He'd said that effectively there was nothing wrong with the system. I think that explains the position with Mr. Jenkins.
Can we now go to Paul 00139906? That's a telephone note of the 14th of August with you and the Scottish solicitors. And if we scroll down 5 paragraphs down, Martin mentioned Susan Crichton, who is head of law at the Post Office. She has now agreed to stop issuing summonses in relation to Post Office cases because of the mess that they are in. And you go on to say in the paragraph, Martin explained the lines of communication have not been very effective. Even legal were not aware of the Helen Rose report initially, only aware of the Second Sight report. And there's then a discussion about the central hub that you've been discussing with
Yes.
Mr. Blake. If If we can scroll down to the second page, you're going on to discuss Brian Altman, then QC, now KC, dealing with the review cases, which include pending cases. And you go on to say, Martin explained they were hoping to meet with, that'd be Brian Altman, during the week of 27th August, and the likely outcome would be that Post Office would agree to obtain an expert report. You didn't know at that point if the Post Office would in fact obtain an expert report. This was just your thinking, wasn't it?
In the second paragraph there, the likely outcome would be that the Post Office would agree to obtain an expert report. So it was expected that the Post Office would. This is also mid-August, when I think in the July meetings, Mr. Clark had advised that Post Office would need to obtain a new expert, and I understand that it was around this time, or probably just before this time, that inquiries were being made with regard to potential experts. So that was very much the intention.
Okay, a final document to go to for just now. Can we go to Paul 00139879? This is the meeting note where you go to meet the officials at the Crown Office and Procurator Fiscal Service, first meeting your solicitors on the 4th of September and then the Crown Office the following day. You, Simon Clark and Jarnell Singh. So quite a bit of effort being put in there, wouldn't you agree, to go, all of you, to Scotland to do this?
Well, I think Mr. Singh flew up from London and myself and Mr. Clark went on the train from Derby.
If we go to that document, I think I gave the number. Yes, there we are. So if we go to the second page, we're at the 5th of, sorry, I think, third page, I think it is, sorry. We're there. Paragraph 9, it was very plain from the PF's current position on Paul that all such cases should be terminated. So that was the main concern for Post Office, wasn't it, that they were going to terminate the cases?
Yes, it was. And I can recall that in London, when myself and Simon discussed it, the legal department were quite concerned that there could be some form of announcement with regard to the integrity of the Horizon system, which could have implications for Post Office.
Yes. Well, if we just scroll down to page 4. Whilst under the English, this is the Crown Office representative, disclosure is to a large extent guided by the defence response and a likely plea. In the Scottish system, disclosure rules dictate that even where the accused has made unequivocal admissions to auditors or interview, disclosure in relating to a corroboration fact occurs ab initio, that's from the start. This situation arises because in many cases the PF does not know what the defence is going to be, and it continues on. If the question is if one piece may be unreliable, that's of the evidence, then it does not qualify as independent, reliable corroboration. Okay, so that's what you were being told. Now, if we scroll down to paragraph 13, Simon Clark then outlined the proposed instruction of independent expert witnesses, and at paragraph 14, a new understanding on the part of those who were there from the Crown Office. This amounted to a departure from his starting point that all Paul prosecutions were to be terminated. Indeed, matters went much further for discussion and then focused on how the present prosecutions were to be advanced. This recommendation amounts to a complete reversal of the PF's original position. I just want to ask you some questions about that. Did you understand, if we take all that has been discussed about what you knew regarding Simon Clarke's advice, the Second Sight interim report, the Helen Rose report, decisions regarding English prosecutions, which aren't mentioned anywhere there, that what you were being told about the disclosure and evidential requirements were actually a higher bar in Scotland compared to what you were used to doing in the courts in England in your private prosecutions?
I don't think I thought of it in terms of a higher bar. I just considered that it was a different legal system and that it would be helpful for an expert report to be obtained to assist. Because at this point in time, whilst you mention Helen Rose, the Second Sight report, the number of issues at that point in time were actually, on the face of it, relatively small. I mean, clearly a lot more has come out since, but at that point in time, the issues appear to be relatively narrow, and so the approach that we had in mind was to get an expert report.
So you're very pleased to note at the end of that meeting you've achieved your objective?
That is what the note says, yes.
And taking all of that together, I'm suggesting to you that you were, at the very least, disingenuous in the way you sought to persuade a Crown officer, a representative of Scotland's most senior law officer, the Lord Advocate, not to terminate all such prosecutions.
No, I don't agree. I'm sorry.
And that what you were doing was to seek to get the entirety of Scotland's criminal justice system onto the side of the Post Office and not terminate the prosecutions of sub-postmasters in Scotland. No,
well, I don't think at this point in time we actually knew what the pipeline of cases was there. This isn't a case of just close every prosecution down. Some of the cases being investigated were not actually, may not actually have been of sub-postmasters or postmistresses. They could have been of counterstaff, and the victims may have been the sub-postmasters or postmistresses. So the approach that we were taking was that it would be appropriate to get an expert report to actually completely deal with the issue of the integrity of the Horizon system so that these issues could be considered.
Sir, I see I've gone just over my time. I've got another couple of questions just to finish off, if I could be allowed. It'll only be maybe another 1 to 2 minutes.
Well, 1 to 2 minutes, and then I'll use my gavel, so to speak.
Okay. This meeting is equivalent to going to, for instance, a meeting with the Director of Public Prosecutions, trying to persuade the DPP to continue with prosecutions when you knew Horizon and the expert witness were unreliable. Do you understand how serious it is to have done that?
I'm sorry, I don't agree. We went to meet with the Procurator Fiscal's office at the request of Post Office with the Scottish lawyers there to explain what Post Office was proposing to do.
Are you aware of the fact that 6 Paul criminal cases in Scotland have this week been quashed by the High Court of Justiciary in Edinburgh, and at least 2 of these cases are ones where pleas and cases took place in the courts in 2012 and 2013, before your meeting, but not far before your meeting? What are your reflections on the quashing of those cases?
My reflections on the quashing of those cases are exactly the same as the reflections I have on the quashing of any other cases. This has turned out to be an absolutely horrendous situation for all those victims, and I'm pleased that they have been quashed.
There you are, Ms.
Thank you, sir. Yes, that's me. Thank you.
So, I'm just making sure I've got these dates right. These meetings in Scotland took place in September 2015. That's right, yeah?
2013.
13. Right, then that's why I'm confused. That's fine, 2013.
So we're going to be hearing from Mr. Maloney next, but perhaps could I just spend 5 more minutes on that particular document? We do have time. I went under time.
Everybody is very persuasive today about getting more time out of me. 5 minutes, Mr. Blake.
Thank you very much. So can we just bring that document back onto screen? it seems as though there was a pre-meeting on the 4th of September amongst yourselves and lawyers from BTO.
Yes, that's correct.
And then if we turn to page 3, there is the meeting with representatives from the Procurator Fiscal Office on the 5th of September.
That's correct, yes.
And amongst those representing the Procurator Fiscal are somebody called Paul Mealy, who is the PF Deputy, correct?
The depute, yes.
Depute. And it begins there, paragraph 8, that he informed the meeting that his role was to formulate a policy recommendation and to put it forward to the Procurator Fiscal. And then we see at paragraph 9, it was very plain from the outset that the Procurator Fiscal's current position on post office prosecutions was that all such cases should be terminated. So you went into that meeting aware that the Procurator Fiscal wanted to terminate post office prosecutions.
Yes.
If we turn over the page to paragraph 12, it says, and this is the first meeting with the representatives from the Procurator Fiscal's office. The previous meetings we've seen are only with solicitors from BTO. Paragraph 12 says, this brief overview of the Scottish system provided the foundation for the discussion which followed. SC, that's Simon Clarke, provided the meeting with a broad overview of the, I think that's Horizon Online difficulties, in brackets, absent any direct or indirect reference to the role of Gareth Jenkins or Fujitsu. Just pausing there, why did Simon Clarke provide the meeting with an overview, first of all, of Horizon Online rather than generally Horizon issues, and secondly, why was it absent any direct or indirect reference to the role of Gareth Jenkins and Fujitsu?
I don't know.
And is it, therefore, following that conversation, a brief overview which gave a broad overview and excluded quite relevant matters relating to Gareth Jenkins and Fujitsu, that the Procurator Fiscal's decision was a reversal of their original position? That's paragraph 14. As a result of this new understanding on the part of Mr. Mealy and his colleague, Mr. Mealy agreed that his recommendation would be that each case be reviewed separately and a decision taken on the facts of the individual case. And the final sentence there, this recommendation amounts to a complete reversal of their original position.
Yes.
So it seems as though that reversal took place after what is described in paragraph 12 as essentially a very limited reference to the issues with Horizon. Is that your recollection of what happened at that particular meeting, the second meeting, the 5th of September meeting that involved representatives from the Procurator Fiscal?
I struggle to recall the entirety of the meeting. I was there taking notes. And if Mr. Clarke has put there that he didn't mention Mr. Jenkins, then that will have been correct.
Paragraph 12, was this note drafted by Mr. Clarke, do you believe?
I believe he was typing it on the train on the way back from Scotland, but he would have had access to my handwritten notes whilst he was preparing it.
And are you able to assist us with why the words in brackets may be in a smaller font or appear to be in a smaller font? Might they have been typed later?
I don't know, I'm afraid.
Thank you very much, sir.
Right. Mr. Maloney, it is, by my reckoning, 14:38, so you can have 22 minutes, and then we'll have a break at 3 o'clock.
Thank you, sir. I'll try and be less than 22 minutes, but I agree it is 14:38. So, Mr. Smith, you described going to see the judge in private in Birmingham Crown Court in the case of Samra on the 1st of July 2013.
I can't confirm that's the date, but I do recall going and seeing the judge in private with Mr. Clarke.
It was listed for trial that day, wasn't it? It doesn't matter if you can't remember.
I don't think it was listed for trial that day.
Right. Well, we can establish that with Mr. Clark later anyway. But essentially, you went to see the judge because you wished to apply to withhold from the defence what you'd heard from Gareth Jenkins about the likely contents of the Second Sight interim report after what he had told them.
I think that's not quite right. It wasn't what we'd heard from Mr. Jenkins.
Right.
I think it was what we'd heard from Post Office Limited about there being a report that made reference to bugs. And I don't believe at that point we had a copy of that. We only knew what we'd been told. And Mr. Clark and I, as you know, had spoken to Mr. Jenkins by telephone, who gave an explanation that there had been 2 bugs. So Mr. Clark decided that he, at that stage, was not in a position to properly comply with his duties of disclosure, because whilst we knew some information, there was clearly more information that we'd want to know. There was clearly a report here that we did not have a copy of, which he thought ought to be considered for disclosure, and he was not prepared, as I understand it, to go through a trial or to commence a trial without disclosure having been properly dealt with. And it was in those circumstances that the application was made. I don't know whether it was actually on the day of trial or a day or two before the day of trial.
Doesn't matter. But essentially, you wanted to withhold from the defence at this stage what you'd been told about what the Second Sight interim report was likely to say about things.
I didn't see it that way. I saw it as Mr. Clark saying that he could not comply with his duties of disclosure. He was prosecuting counsel in that case, and that was his view.
Okay. Well, let's just try and develop that, please, Mr. Smith. You went to see the judge in private to make an application.
I went along with Mr. Clark's, who was making the application.
It's an ex parte application. It means the other party's not there, doesn't it?
That's correct, yes.
And your application was a public interest immunity application, wasn't it? Did you understand that?
I don't think I did at the time. I just knew that Mr. Clark was making an application and I was making notes of it.
Right. So when you say you didn't understand that at the time, do you understand that that's what it was? Do you understand now that that's what it was?
I believe that that's what it was. I don't recall it well enough, except to say that Mr. Clark was explaining to the judge that he could not disclose the correct material at that particular point in time. Not that it would not be disclosed, it was just that he wasn't in a position to discharge his disclosure duties at that time.
I'm sorry to interrupt, but that's telling the judge what he can't do. What exactly was he asking the judge to do?
I'm afraid so, I can't recall.
Well, I mean, was he saying, look, I've got this problem, but that we should proceed with the trial anyway? Was he asking for the trial to be adjourned? What was he doing?
No, I don't believe that he was going to proceed with the trial.
So he was asking the judge, what, to adjourn the trial or to enter a not guilty plea against the defendant? What? The judge must have been asked to do something specific.
So I'm afraid I can't remember.
Right.
I really can't remember. I remember.
I'll try and help you with your recollection, Mr.
I remember
Just
turning up and taking notes.
Okay, I'm sorry to the stenographer for talking over for us talking over each other there. I'll try and assist you with your recollection, okay? Because what actually did happen was that a public interest immunity application was made on behalf of the prosecution, Post Office Limited, okay?
Okay.
And you know that now anyway, don't you?
Yes.
Yeah. And you know, you've said that, of course, you practiced in defence for a number of years, but you were relatively new to prosecution, so you took Mr. Clark's advice and were guided by him as to the making of this application.
Well, it wasn't the case that I was guided by him in the making of the application. He made the application and I was there taking notes.
But you were as instructing solicitor, to all intents and purposes, Mr. Smith, weren't you? A very experienced solicitor. You were there with counsel who you worked with, hand in glove, it seems, from all the correspondence that we've seen. You were a 3 on this occasion, you were a 2. You worked together.
I was working with him on that day, yes.
Entirely. And so, did he not tell you what he was doing?
I cannot recall enough about the day, I'm afraid.
Right, okay. Well, I'll try and assist. A public interest immunity application, as a defence solicitor of some experience, is an important procedure, isn't it? It essentially withholding material from the defence which would be helpful to the defence and would ordinarily need to be disclosed. That's what it's about, isn't it?
That is a PII application, yes.
And you were aware, were you, of the important House of Lords case of H&C and the conditions it laid down for when a public interest immunity application should be made?
I can't say that I could recall that.
Right, okay. But as a solicitor, would you know that really that it should only be made where a prosecutor has identified material that should be disclosed, but disclosure of it would create a real risk of serious prejudice to an important public interest, and the prosecutor believes that the public interest in withholding the material outweighs the public interest in disclosing it to the defence? Would that accord with your general appreciation of the rules in relation to public interest immunity applications?
I can't say that I had previously come across a PII application.
Right, okay.
So that's new to me.
But you not remembering much about this, did Mr. Clark give you any reason as to why he was making the application to withhold the second sight report? You previously mentioned yesterday something about parliamentary privilege, Mr. Smith.
I can recall a conversation that I had with Mr. Clark. I'm afraid it's all a little hazy because it's such a long time ago, but we were very much aware that the second sight report was going to be released to members of Parliament before it was going to be published generally. And I think at this particular point in time, we did not have the report, and we only knew snippets of what it was likely to contain.
Right. Did Mr. Clark say to you that one aspect of the public interest that he was asserting to the judge in his application would be the prevention of a widespread loss of confidence in Post Office?
I don't recall that being said.
Did he say that another aspect would be the loss of trust in a system operated by Post Office?
I'm sorry, I just don't recall the conversation.
Finally, just ask you, just for the sake of it, did he say that another aspect would be the prevention of journalistic speculation as to the efficacy of systems almost universally relied on by the public?
I don't recall that either, I'm afraid.
And then, finally, did he say to you that, essentially, Post Office Limited were rightly, in my opinion, very concerned at the potential adverse publicity which would inevitably have been generated by the revelation of the existence of a draft second sight report into Horizon? To permit this information to enter the public domain at such an early stage would have been to encourage extremely unhealthy and likely virulent speculation as to the content of any report, most probably in the national press. Such speculation would have seriously damaged the reputation of Post Office Limited and would have greatly undermined public confidence in both Post Office Limited and Post Office Limited systems. Our objective was to avoid such consequences. That objective we achieved with the public interest immunity application.
I don't recall that, I'm afraid, either.
If Mr. Clark had set all of those things out that I've just asked you if you remember him saying in a note of the day's hearing, would you have seen it? A note sent to Paul, an attendance note?
I don't recall seeing an attendance note, no.
Would you ordinarily have seen such an attendance note, Mr. Smith?
Sometimes I was asked to look at things, proofread them, and sometimes Mr. Clark would go through things, and other times I wouldn't. I'm afraid it doesn't ring any bells with me.
No. I don't, obviously, you can probably see that I am actually saying that Mr. Clark did set that out in the attendance note.
I'm gathering from the way you're asking the questions that you're reading from an attendance note written by Mr. Clark, but I'm afraid it doesn't ring any bells with me at all.
Right. Were the defence, Mrs. Samra's lawyers, put on notice that you were going to make a PII application?
I have no idea. I have no idea.
This was your very first PII application, Mr. Smith, either defence or prosecution, was it? In all your years of experience?
Well, I'm afraid I have absolutely no idea about this. I know that Mr. Clark was prosecuting counsel, and I don't know.
Did you have any role in notifying Mrs. Samra's solicitors that there was going to be a PII application made on the 1st of July 2013?
I'm not aware that I did.
So you can't help whether or not any notice was given?
I'm afraid I've got absolutely no idea.
Were you aware that if the prosecutor makes an application to the court without notice to the defence, because the only circumstance in which it can be done is because it would have the effect of disclosing that which the prosecutor contends should not in the public interest be disclosed, and that is a highly exceptional situation?
I'm sorry, what was the question?
Were you aware that when a prosecutor makes an application to the court, and this is under the criminal procedure rules, without notice to the defence, because to do so would have the effect of disclosing what the prosecutor contends should not be in the public interest be disclosed, that's the only circumstances in which an application can be made without notice to the defence?
No.
Are you aware of that?
I wasn't aware of that, no.
No. But an application was made by Mr. Clark, with you in attendance making notes as a solicitor of some post-qualification experience, and you went into the judge's chambers with Mr. Clark, and the judge himself was a Judge Chambers, wasn't he? Do you remember that?
I'm afraid I don't know.
And what happened was, you were to, as a PII certificate was granted. Were you aware of that?
I don't recall.
Right. And you were to inform the defence that a report had been commissioned, but you could withhold the existence of the interim report, and it was to be presented to MPs that day. And then the matter was adjourned for 8 weeks. Are you aware of that?
I don't recall that, I'm afraid.
Right. Thank you very much, Mr. Smith. So that's only 18 minutes, I think.
Very good, Mr. Maroney. Mr. Steen, can I press you in the sense that I think you were next and you wanted 15 minutes, and if that is accurate, then we could probably slip that in before our break.
So I think it is accurate. I'll be 15 minutes, but I'd hope to be slightly less.
Right, well, even more reason for you to carry on, if you will, please.
Great. In that case, Mr. Smith, let's proceed with the questions I have for you. At the time whereby you, working for Cartwright King, were engaged on the prosecution of matters for the Post Office, do you agree that you were following the code of practice for prosecution advocates that was issued by the CPS?
I wouldn't agree that, no.
You weren't. What code of practice in relation to your prosecution work do you think you were following?
I'm not confident that we had the necessary skills and expertise to be able to follow codes. I'm afraid, as I said earlier, we're essentially a defence firm of solicitors, and it's beyond me as to why the firm decided to take on prosecution work, knowing that we hadn't been specifically trained in prosecution work. And so, whilst there may invariably be codes of practice and other requirements, I think it's difficult to follow them if you're not aware of them.
Understood, Mr. Smith, but it's you taking on the work. You are an advocate, by this point an advocate of some experience. You had qualified as a higher rights advocate well before 2010. Do you agree?
That's correct.
And it is you that is subject to the regulatory responsibilities issued by the Bar Standards Board. Do you agree? Do you agree?
Sorry, could you just repeat that?
You are Sorry, you're a solicitor, aren't you? So you
Yes.
are subject to the regulatory responsibilities of the issued by the SRA, the Solicitors Regulation.
Yes.
Do you agree with that? And you agree that you should work within your own field of competence? You
Yes.
also accept that?
Yes.
So when you started to take on prosecution work on behalf of the Post Office, did you consider the question of what ethical standards should apply to your work as a prosecutor?
I didn't consider that it didn't occur to me that I did not have the requisite skills and expertise for this role.
Did you look them up?
No, I didn't.
Now, in old-fashioned terms, the way that the standards applied to prosecutors used to be called a Minister of Justice. Did you consider, even in the loosest possible way, that you as a prosecutor needed to act as a Minister of Justice?
I considered that I needed to do things properly in accordance with the law, and that is what I attempt to do.
Have you heard the term Minister of Justice being applied to prosecutors?
I have, yes. Now.
Right. Let me ask the question again. Did you consider that that should be the way that you should act when prosecuting?
That is certainly what we try to do, yes.
Did you think about it, Mr. Smith, that I must, when prosecuting these cases, act in a way that is bringing the highest ethical standards to apply to prosecution cases? Did that cross your mind or not?
I don't think I gave it a huge amount of thought.
So the answer is no, I didn't.
No.
All right. Let's turn to then the call that you had with Mr. Jenkins, and that was prior to then the issue of what we all call the Clark Jenkins advice.
Yes.
Okay? Right, that call. Now, that call was recorded.
Yes.
By the time, therefore, that the call with Mr. Jenkins was recorded, do you agree that you and Mr. Clark were, at the very least, suspicious that there was a problem with Mr. Jenkins?
Suspicious, yes.
Yes, otherwise why record the call?
Oh, yeah, yes.
So this wasn't an example of Mr. Jenkins being told, by the way, we're going to record this call because we think there's a few things that are of real concern. You didn't warn him that you're about to call him?
We didn't warn him, no.
No.
And we were obviously concerned that reports that had been provided did not make reference to the bugs.
Why was it recorded?
So we could have a transcript of it for our own files.
Right. So the transcript was there and the call was there so that you would have evidence in relation to what was going on with Mr. Jenkins. Is that right?
Yes.
Okay. So you and Mr. Clark were conducting essentially a mini investigation at that stage into Mr. Jenkins. Is that correct?
I suppose putting it like that, yes.
Yes. Okay. So it then led to the Clark advice that deals with Mr. Jenkins. I'm going to ask for that to go up on the screen, please. And that is POL 40 6357. And can we have paragraph 38 at page 13, the bottom half? Page 13, paragraph 38, please. Okay. Now, this says at paragraph 38, the reasons as to why Dr. Jenkins failed to comply with this duty are beyond the scope of this review. The effects of that failure, however, must be considered. I advise the following to be the position. Dr. Jenkins failed to disclose material known to him, but which undermines his expert opinion. So that is basically saying that Mr. Jenkins, Dr. Jenkins says here, deliberately failed to disclose material that he was aware of. Do you agree?
Yes.
Right. This failure is a plain breach of his duty as an expert witness. And then it goes on to say, accordingly, Dr. Jenkins' credibility as an expert witness is fatally undermined. That's what it says. Do you agree?
Yes.
Right. Okay. Now, at this stage, therefore, you're considering the question of someone who has knowingly misled the courts. Do you agree?
Yes.
Right. What criminal offences has been committed if those facts are correct?
Well, perjury, potentially.
Right. Anything else?
Perverting the course of justice.
Right. So let's go with perjury and perverting course of justice. Let's ask the basic question. Why didn't you call the police?
I don't know.
Nowhere in the clerk advice dealing with Mr. Jenkins does anybody suggest that maybe we should just call the police and bring them in to conduct an independent investigation. Do you accept that it's not in that advice?
I do accept it's not.
Do you accept that it's not in any other advice that relates to Mr. Jenkins, that maybe it might not be a good idea to call in an independent investigation, i.e. the police?
No, I just don't think that's anything we thought of.
Right. And at the time, after having conducted the investigation involving Mr. Jenkins, including the taped call, did you not consider yourselves then to be witnesses in relation to what had happened regarding Mr. Jenkins?
I didn't think of that, no.
No. Do you accept that you are witnesses in relation to what happened to Mr. Jenkins and those calls and that investigation?
I do, yes.
Yes.
No, putting it that way, I do, yes.
Well, putting it that way is all fairly obvious, Mr. Smith. When considering your position as a witness, do you think it was appropriate to continue acting on behalf of the Post Office in relation to these matters?
I didn't think of it in that way.
What do you think about it now?
I can very much understand your point.
Do you agree with it?
I'm not sure I do.
Okay, why not?
Because the fact that we've become aware of this information, we've mentioned it to our client, and we are then assisting our client to move on in terms of looking at cases, reviewing files, and looking for a new expert.
But not calling the police. What did you tell Fujitsu?
I don't believe we said anything to Fujitsu.
Mr. Jenkins is employed by who?
Fujitsu.
Yes. And you come to the conclusion that Mr. Jenkins has misled the courts dishonestly. What did you not consider it might not be a bad idea to tell Fujitsu about their employee?
I didn't give it that any thought. Perhaps I thought that Post Office might do that, given that they are the ones with a contractual relationship with Fujitsu.
It didn't cross your mind or Mr. Clark's mind, as far as you're aware, to perhaps tell the Post Office that it ought to tell Fujitsu that they're, on your view, that their expert has been dishonest with the courts?
No, I don't believe. No, myself and Mr. Clark did not discuss that. We didn't discuss the fact that we were potential witnesses. We did not discuss the possibility of informing the police or Fujitsu.
Right. Now let's deal with the shredding advice, also penned by Mr. Clark. Now the shredding advice came about because what had happened was that you had learnt from Jarnell Singh in a conversation again you recorded that Mr. Scott, head of security at Post Office, was suggesting that minutes should not be kept, otherwise they might be disclosed. Do you agree?
I don't agree fully with what you've said. It wasn't an entirety of the phone call that was recorded. It was just the latter part that was recorded.
But that was the thread of what was in the shredding advice.
It was the shredding. If we're going to call it the shredding advice, contained information relating to that call and also as a byproduct of some of the Wednesday morning calls.
Yes, the shredding advice does not record that there was also a comment made to Mr. Singh and reported to you that what was going to happen was that Cartwright King were going to be blamed for destroying documents. I read from your statement. Paragraph 45, page 12. My recollection at the present time is that Mr. Singh alleged that John Scott had indicated an intention to shred the minutes and to explain, if asked, that they had been destroyed on the advice of Cartwright King. And you repeat that in relation to the same conversation at paragraph 52, page 14. Now, the shredding advice does not record the fact that essentially Mr. Scott was apparently willing to blame Cartwright King for shredding of evidential material. Why does it not record that?
I don't know.
Is it not a serious accusation?
It is, yes.
And a serious suggestion to be made in relation to a firm of solicitors?
Yes.
Did you tell the partners of the firm of Cartwright King?
I would have reported it to Mr. Cash, undoubtedly, who
Yes.
is the partner in charge of the Derby office. I can't recall precisely whether I spoke to the other partners.
Well, what was Mr. Cash's reaction? Was he delighted?
I don't think anyone was particularly
Right.
delighted about that suggestion.
By this point, in July of 2013, do you agree that you and the firm of Cartwright King were hopelessly conflicted in relation to your dealings with Post Office?
I don't think that crossed our minds.
Did you take any advice on that?
I just simply reported what had happened to Mr. Clark, and that was it, really.
Were these advices privileged, Mr. Smith?
What do you mean by that?
You understand what privilege is. It's the duty of confidentiality
Yes.
that exists between lawyers and clients.
Yes.
And it allows for a lawyer to advise in private a client. Were the contents of these advices, in other words, you discovering via a mini investigation with Mr. Jenkins that he apparently, on what you know, has misled courts, is that privileged material, Mr. Smith?
I'm really not quite sure.
And what about the shredding side of things? The fact that John Scott, head of security at Pole, was both threatening Cartwright King and suggesting that evidential minutes should be destroyed. Is that privileged, Mr. Smith?
No, that's not.
No. No further questions.
Thank you, Mr. Steen. We'll now have our break. Mr. Blake, can you ask the transcriber whether she requires 15 minutes or whether 10 minutes is enough? I'm comfortable with either.
She would like 15 minutes.
Fine. So we'll start again at 3:20.
Yes, thank you very much.
Fine, thank you.
Thank you, sir. We're now going to turn to Mr. Henry.
Mr. Henry, I think you've asked for 5 extra minutes, so 20 to 4.
Thank you, sir.
Yeah, fine.
Thank you very much, sir. Could we go to POL 001 39866? And these are notes that you took of a meeting with Mr. Brian Altman, correct?
They are a typed version of the notes that I took. I wasn't
Fair
typing
enough,
during
but
the
you
meeting.
accept they are your notes?
Yes, I typed these.
Thank you. You'll remember, of course, that this was the conference where Mr. Altman advised that there was no positive duty to seek out individuals pre the 1st of January 2010, correct?
Yes, that's correct.
Could we go to page 3 of these notes, please? And do you see the word Susan? That stands for Susan Crichton.
Yes.
Better to keep Fujitsu on OS outside, given not resolved GJ Gareth Jenkins situation.
Yes.
And then the QC says, tactical point of view, keep them as third party.
Yes.
So in other words, keep them at a distance, correct?
Yes, I'm not quite sure in what context that is, but yes, that's the reading of it.
Well, I mean, you must surely have reflected upon this. When did you realise you were going to become a witness in this inquiry?
No, what I mean by that is I'm not sure whether that is in relation to the provision of information from Fujitsu.
It was better to keep Fujitsu on the outside, given not resolved the Gareth Jenkins situation. I'm not going to waste my 20 minutes by waiting for an answer. Shall we move on to page 6, please? And do you see just at the bottom of the screen, QC, Misra concerned, pre-Horizon Online case, issues were as detailed as I've seen. She went to prison, Jenkins gave evidence, training and Horizon issues, Professor McLaughlin, much of it hypothesis. That is a case slipping through the net.
Yes.
You realise, of course, that I am sitting next to Mrs. Sema Misra today.
I didn't realise that.
Yeah. And you would agree that she's owed the truth.
Yes, absolutely.
Right, so I'm going to ask you some questions. Miss Crichton says, she comments that she has applied for mediation, and then the QC says, how are we going to deal if she comes forward and says similar? You see that?
Yes.
So she's got to come forward. No one's going to tell her. That was the gist, wasn't it? How are we going to deal if she comes forwards and says similar? It's obvious. She's got to come forward. The impetus is on her. No one is going to tell her.
Well, it leads into the next sentence, doesn't it?
Precisely.
Susan, either review all pre-2010 cases or we do nothing and wait for them to come forwards.
Exactly. And that's precisely what occurred.
Yes, I think what occurred was that there was a decision to review cases which commenced after the 1st of January 2010, that being the earliest date upon which Horizon Online could have been in place. But I think we changed that so it was any case with a hearing after the 1st of January 2010, which of course then included Mrs. Misra's case.
Well, we'll come to how you deal with it, but I note your apparent justification for the decisions taken at this conference and subsequently. But it seems at this stage no one wanted to provide Mrs. Misra with a ticket, to use your expression, to the Court of Appeal. Do nothing, adopt a passive approach. Correct?
I would certainly agree that the Post Office did not want at that stage to be actively encouraging people to go to the Court of Appeal.
No. And you know why that was, don't you?
I take it you're going to enlighten me.
Oh, come on. Must we play games, Mr. Smith? I'm sitting next to a lady who was the foundation stone for the prosecution policy. Her case was a test case which was used to deter civil claims and criminal defences. The conviction obtained against her was absolutely seminal in the whole prosecution policy. You must have realised that.
I was aware that Mrs. Misra had been prosecuted. I think at the time of this conference, I don't think we had seen her file. I think we were being told that her file was not available. It couldn't be found. And I think the first time her case was reviewed was, I think, by Mr. Clark having to read the judge's summing up to the jury. And I think that was also provided to Mr. Altman, King's Counsel, and I think he commented that a particular page was missing. It wasn't until quite some time later that the case file relating to Mrs. Misra was discovered and provided.
Can I just ask you, please, to keep your answers short, because they're eating into my time and I've got quite a lot of things to put to you.
I do apologise.
Right. I'm going to go and ask you this question. In view of the answers you've given to Mr. Steen, King's Counsel, and in view of what you already knew by this time, namely the 28th of June recorded conversation, the 15th of July advice, why wasn't Mrs. Misra immediately being told?
I don't know.
Well, I suggest the reason is obvious, and it is going to be clear from the evidence that you've already given to Mr. Blake. It is because of the fact that if disclosure had been made to her promptly, it would have, as it were, set off the domino effect, wouldn't it?
I don't think that I gave any thought to that whatsoever.
Well, you have spoken, haven't you, about how you were concerned, how the civil lawyers, Roderick Williams, Mr. Parsons, etc., the civil lawyers appeared to be exerting pressure, talk of suppressing disclosure, talk of not putting things in writing, etc.
In civil litigation.
Yeah. But of course, if Mrs. Misra's appeal was promptly notified to her, an irresistible appeal, you surely don't dissent from that judgment.
No, I think the plan of action was that all cases should be reviewed, and they should go through the civ process. Then senior counsel would conduct a full review to determine whether disclosure should be provided. And that is precisely what happened in relation to Mrs. Misra's case. I'm afraid I don't recall having any particular involvement with Mrs. Misra's case.
Well, we'll come to that. It seems you agree at that stage that you didn't want to provide Mrs. Misra with a ticket to the Court of Appeal. And then these words, that there may be Misras, other Misras, we can't avoid, this is the QC, provisional view, sensible date to adopt, in other words, the 1st of January 2010, but can't avoid possibility Misras may crawl out of woodwork, deal with on a case-by-case basis unless someone states cut-off is unreasonable. In other words, do nothing pre-2010, but some applicants may yet emerge, deal with them ad hoc, unless someone challenges the 2010 cut-off as being unreasonable. You agree with that?
That was Mr. Altman, King's Counsel's advice, yes.
Right, let's go to Mr. Matthews, page 7, please.
Before you go there, Mr. Henry, and
Certainly, sir.
And I'll give you an extra minute because I'm interfering. What does Misra unique mean so far as you're concerned, Mr. Smith? You see just a couple of lines down from where the point Mr. Henry took you.
I'm afraid I have no idea, sir. I've got no idea.
Let me jog your memory. It's because it's the only case in which Mr. Jenkins gave oral evidence against a defendant, although he had given written evidence. That's why she was unique.
That may be the case.
Right. Go to page 7, if we may. And Mr. Matthews says, Misra, apologise. And the QC is reported to have said, I wouldn't. You wouldn't have written that down if that wasn't accurate, would you, Mr. Smith?
No, I wouldn't.
No. Because, of course, an apology would let the cat out of the bag. It would let the Jenkins cat out of the bag. So, therefore, there was an approach of do nothing, masterly inactivity. Correct?
I don't believe that Mr. Jenkins was discussed in relation to this.
Well, what would you be apologising for? What would the apology for Mrs. Misra be for if it weren't to be in connection with the fact, oh, I'm sorry, we secured your conviction on the basis of an expert who did not know his duties to the court and who may, on the information that we have on tape, suppressed vital information about bugs, errors and defects. You know, even Mr. Matthews thought that maybe that deserved an apology, didn't he?
I think this may have been discussing the way in which her mediation application may have been dealt with, and
well, I can deal with that in very short order because Mr. Altman said don't mediate with her, didn't he?
Well, he was against mediating with anyone who had a conviction. Yeah. He was very clear in his advice in relation to that.
Yeah. As we can see on page 7, see mediation for anyone who is outside scope of criminal scheme. I think storing up problems is a phrase I underline. Is she considering out-of-time appeal? That must be a reference to Mrs. Misra. You agree?
I do agree, yes.
Page 8 of 11. No problem with mediation, however, do have a problem with someone going convicted to the scheme. My view is storing up problems with Misra. So his clear and unambiguous advice was don't mediate with her.
Yes, that's correct.
Foot of page 8, please. And do you see foot of page 8, please? Yes, we got it. 5 lines up from the bottom. At the moment, on the right lines, just control it. That's again Mr. Altman speaking, isn't it?
I believe so, yes.
Yeah, and of course that echoes the Altman General Review at paragraph 129 that Mr. Blake took you to this morning, where Mr. Altman writes, Cartwright King wished to exercise a measure of control over the dissemination of information and material during the process. So this is where, I suppose, Mr. Altman is basically saying, yes, keep a vice-like grip on disclosure. Correct?
He was advising to be very careful what was disclosed, yes.
Keep a vice-like grip on disclosure. Keep it tight.
I don't recall the words vice-like grip being mentioned.
Well, he didn't want anything to be loose, did he?
I think his view, well, as I understand his view, he was very much of the view that a casual comment or a throwaway comment or even an apology could actually have substantial ramifications for Post Office.
Right. Now, I want to understand now, in the remaining minutes that I have, how a decision was taken on the 5th of December 2013 when the firm said, and it was the firm, that Mrs. Misra should have disclosure, because on the 5th of December 2013, POL 001 98595, and it's a matter of record, it's paragraph 33 of that document. It is our view that this case clearly passes the disclosure threshold, and we will be disclosing the second site interim report and the Helen Rose report to Misra's lawyers. It should be said, however, that the defence were aware of the Falkirk defect in this case, and it was discussed in the trial. This is the only pre-Horizon online bug of which we are aware. So 2 questions arising out of that paragraph. Who wrote that paragraph?
What's the name at the bottom of the document?
Cartwright King.
Cartwright King. Well, it certainly wasn't me who wrote that paragraph.
You were involved in the preparation of this document. You say so in your statement.
Yes.
Can you not tell Sir Wynne, the chairman of this inquiry, to the best of your recollection, who wrote that paragraph?
If it just simply says Cartwright King at the bottom of the document, I would guess that that was written by Mr. Bowyer, because Simon Clark would generally sign off his paragraphs, sign off his documents, Simon Clark.
I see. And so I now ask you this question. Why was Mr. Bowyer taken off this matter? Because on the 22nd of January 2014, Mr. Clark sent you an email which had the full review of the Sema Misra case, draft document, and he said one word in that email to you when he sent it to you. It was "few," triple exclamation mark. Who took Harry Bowyer off the case and put Simon Clark on it?
I'm not aware that anyone took Harry Bowyer off the case.
Well, why didn't Mr. Bowyer, if he wrote paragraph 33, have continuing control of the matter? Why was it that on the 22nd of January 2014, Mr. Clark sends you an email with the word "few," attaching a document which says that Mrs. Misra shouldn't have any disclosure?
I don't recall that.
And you responded to it as "one complex matter ends, another starts." You were in on this, weren't you? Tell us the truth. Why did the firm do a complete backflip somersault on whether Mrs. Misra's team should get disclosure?
No, I don't recall appreciating that there was a complete somersault.
Are you being serious, Mr. Smith?
I am being serious with you. Yes, I'm being deadly serious with you. I remember that the initial review of Mrs. Misra's case was a partial review based on the judge's summing up, and then Mr. Clark looked at that, and it would appear from what you're saying that he then reached that decision. I'm afraid I can't add anything more to that.
Can we go back to first principles? 28th of June, 15th of July, expert witness credibility facially undermined. If Mr. Jenkins had given evidence either orally or in writing against any defendant, the material that you had from the 28th of June and the 15th of July was material that would cast doubt upon the safety of any conviction associated with his evidence, wouldn't it?
I agree with that now, yes.
You should have agreed with it then, and you did agree with it then, because of the 5th of December 2013 document that went out in your name, saying that she ought to have been given disclosure. What happened between the 5th of December 2013 and the 24th of January 2014? Tell the truth.
I have got no idea. As far as I was aware, Mrs. Misra's case was being looked at in accordance with the protocol. I'm speculating, but it may be that by the time Mr. Clark had looked at it again, we perhaps had more information.
You were in daily contact, you told Mr. Blake, with Jarnail Singh.
Almost daily.
Again, I put it to you that if Mrs. Misra's lawyers had been given prompt disclosure, the whole prosecutorial facade of Horizon's reliability and infallibility would have collapsed, wouldn't it?
Her case was assessed by Mr. Clark, who, as you've said, concluded that no disclosure was necessary.
We know that, but
the
reason why he said that, I suggest, is because somebody obviously put pressure on him because of the ramifications Mrs. Misra's inevitable appeal would have had for both civil and criminal litigation.
Well, that's, with respect, that's nonsense, and it certainly wasn't.
Why is it nonsense?
Well, I've not put any pressure on Mr. Clark. None at all.
And you can offer no explanation at all for Mr. Bowyer not continuing with carriage of the matter and that fundamental shift between the 5th of December 2013 and the 24th of January 2014, or forgive me, the 22nd of January 2014. You can offer no explanation.
No, all I can think of is by that time it may be that we had more information, because to start with, as I've already said, there was very little information available, and then I think the file was then discovered and sent through. Now, how that fits into the timescale, I'm not sure. But
I'm afraid that your assumptions here are incorrect, as would be clear if you had read the 22nd of January advice. I ask you for the final time, and my time is up, what is the truth about the firm's shift between Mrs. Misra should get disclosure in December 2013 to Mrs. Misra ought not to get disclosure under any circumstances on the 22nd of January 2014?
I cannot give you any information in relation to that. All I can suggest is that you ask Mr. Clark as to how he came to his conclusion.
Thank you, Mr. Henry. Right. I think the final series of questions comes from Ms. Oliver.
Thank you, sir. Mr. Smith, I ask questions on behalf of Gareth Jenkins. I hope you can just about see me.
And for the avoidance of doubt, your time limit is 4:05, Ms. Oliver.
I'm grateful. Thank you, sir. I have 3 topics that I want to cover with you this afternoon. Firstly, the question of expert duties. Secondly, the call that you conducted with Mr. Jenkins in relation to the case of Samra. And thirdly, a discrete element of your treatment of Mr. Jenkins in the case of Ishak. All right, so to turn to the first of those then, you have very candidly accepted that at the time you were prosecuting these cases, you were not aware of your duties in instructing and deploying expert evidence. Is that right?
That's correct, yes.
And following what you said, that it's difficult to follow something of which you are not aware.
Yes.
You also candidly acknowledged that Cartwright King never instructed Mr. Jenkins in a compliant manner and never told him about the expert duties to which he was subject.
That's also correct, yes.
Thank you. The way you deal with that in your second witness statement, I don't think we need to go to it, it's paragraph 21 of that statement, is that you state Mr. Jenkins should have been given detailed written instructions in relation to each individual case, which enclosed a full set of papers, asked specific questions, and set out the duties of an expert instructed by the prosecution. Mr. Jenkins had not been so instructed. Is that correct?
Yes, that's right.
In that paragraph 21, you don't specify between Cartwright King and Post Office in terms of their instructions. Did you come to the same conclusions as to the non-compliant instruction of Mr. Jenkins in relation to Post Office's use of him in the prosecutions they conducted before Cartwright King became involved?
I'm sorry, I'm struggling to see you.
I know.
There we go.
I'm going to come this way. Hopefully that will be easier.
Oh, no, I'll go back that way.
Thank you.
Okay.
That's very kind of you. Thank you.
I took the view that it became apparent to me, following the provision of Mr. Clark's advice, that we had not been compliant in terms of instructing Mr. Jenkins. Mr. Singh, who had followed Mr. Bowyer's advice, had not been compliant in instructing Mr. Jenkins, and of course Mr. Singh was head of criminal law at Post Office, and in the circumstances I was quickly coming to the view that actually when the Post Office was part of the Royal Mail Group, it was highly unlikely that he had ever been advised of his duties then either. Otherwise, even though there was a requirement to advise him on each occasion, which I was unaware of, it occurred to me that he'd probably never been advised at all.
Thank you. So the answer to my question then is that it did relate both to Cartwright King's instruction and to Post Office's.
Yes.
Thank you. Do you agree that that was a serious failing on the part of Cartwright King and Post Office in the manner in which they conducted these past prosecutions?
It was a serious failing in terms of how they obtained expert advice.
Thank you. And do you agree that it's particularly important because it goes to the very failing that Mr. Clark identified in his advice of the 15th of July 2013, by which I mean the failure to disclose material in accordance with those expert duties?
It does go to that, yes.
Thank you. I think you said in answer to my learned friend for Counsel to the Inquiry that you knew of that failure, certainly in relation to Cartwright King, at the time that Mr. Clark was producing the advice of the 15th of July. Is that right?
It was that advice which really drew my attention to it.
Is it something that you discussed with Mr. Clark at the time he was writing that advice?
I don't recall discussing it with him.
Are you aware of whether he was aware of that lack of expert instruction at the time he was writing his advice?
I don't know.
Thank you. Can we please go to a document? It's POL 001 55 555. Thank you. This is a handwritten note. You can see the date in the top right-hand corner. It's the 2nd of September 2013. We've heard evidence that this was a note authored by Roderick Williams of Post Office. It appears to refer to you at a number of points. I'm just going to identify those for you. About halfway down the page, we can see it seems to be the words tell to MS. Do you see that?
Yes.
And then if we scroll down a little bit further, please, we see on the left Martin Smith and then the word inference, and then a few lines down, M. Smith. Do you recall having a conversation around this time with Mr. Williams?
No, I'm sorry, I don't.
All right. If we go to some of the things he records that might jog your memory, on the right-hand side of the page we have in front of us at the moment, in the box, it says, what were we doing to instruct GJ? And then on the left of the page, under the words M. Smith, are a number of arrow bullet points. The first of which is don't think he's ever been advised of his duties. Do you think that this note might be recording a conversation that you had with Mr. Williams?
It's quite possible, yes.
And do you recall whether during a conversation you had with Mr. Williams, you informed him of your view that you've informed us of this afternoon, that you don't think Mr. Jenkins had ever been advised of his duties?
I can't recall the conversation, I'm afraid.
All right.
It's such a long time ago.
Do you recall being party to any other discussion with anyone within Post Office as to the conclusion you'd reached that Mr. Jenkins had never been properly instructed as an expert?
No, I don't.
And if, as this note appears to indicate, you were having that sort of conversation with Mr. Williams, does that make it more likely that that's a conversation you would have had with Mr. Clark as well?
I may have had that conversation with Mr. Clark, but I can't say it makes it more likely. I just don't know.
All right, thank you. Can we please turn to poll 001398666? This is your typed note of the notes that you took during a conference with Brian Altman QC on the 9th of September of 2013. If we could go to page 4, please, about halfway down. And it's the entry, thank you, that starts Simon, and then it says, goes back to GJ, either he not aware of info or FJ Ivory Tower not being taken seriously. Do you recall what that comment from presumably Simon Clark referred to?
Yes, I can recall that there was a discussion about Mr. Jenkins. And I think I actually wondered whether he'd actually become aware in a timely fashion of the various bugs himself. And according to this note, Mr. Clark's view was either he wasn't aware of the information, or alternatively that FJ, meaning Fujitsu, was in an ivory tower and not taking their obligations seriously.
As part of the discussion about Mr. Jenkins that appears to have featured in this conference, did you at any point tell Brian Altman QC of your conclusion that Mr. Jenkins had never been instructed in a compliant manner and had never been told about his expert duties?
No, I don't think that occurred to me.
All right. Can we please turn to the Simon Clark advice? It's poll 00006357. And can we go, please, to paragraphs 37 and 38, which I think are on page 13. Thank you. So there we see at paragraph 37 the conclusion that I've already referred to, that Dr. Jennings, meaning Jenkins, has not complied with his duties to the court, the prosecution or the defence, and it sets out the expert duty of disclosure there. And then at paragraph 38, the reasons as to why Dr. Jenkins failed to comply with this duty are beyond the scope of this review. Do you know why those reasons were considered beyond the scope of this review?
No, I don't.
Is it because the reason it appeared you knew at that point, at the very least may have been, and by the reason I mean the reason for Mr. Jenkins' failure to comply with that disclosure obligation, may have been that he was never told about the very duty he was accused in this advice of breaching?
I think Mr. Clark was concentrating on the effects of the failure, not the method of instruction, because we knew at that stage that Mr. Jenkins had been instructed, obviously, for quite some number of years, whereas Cartwright King had been involved at that stage for approximately 1 year.
Well, all of the statements that Mr. Clark refers to in this advice concern statements obtained by Cartwright King.
Yes.
All right. So that's certainly the focus of his
I believe
discussion.
I handed them to him.
All right. But did you not think it relevant, the manner in which Mr. Jenkins had been instructed of the expert duty that he was accused in this advice of breaching?
No, I didn't give that thought, I'm afraid.
On any view, do you agree that what you discovered about the lack of instruction of Mr. Jenkins was a hugely relevant factor, hugely relevant material to anyone who was looking at the conduct of past prosecutions, whether that be Post Office or Cartwright King?
I can see that now, but I didn't think about that at the time.
Do you agree that that conclusion that you had reached as to the lack of Mr. Jenkins' instruction ought to have been communicated to Mr. Altman, to Post Office, to the CCRC?
I'm afraid I didn't think of it in that level of depth.
Is the reason why there was a lack of openness about that conclusion that you had reached because it would have been professionally damaging to Cartwright King to make that concession?
No, I just didn't think of it in that way. I mean, I was looking at it. In fact, you know, this is where we are now. We have these reports. They didn't mention bugs. What are we going to do about it?
And had it become known, Mr. Smith, that there had been that acknowledged failure on the part of Post Office and Cartwright King, that would have led to an obvious conflict for your firm continuing their involvement in reviewing those past prosecutions, wouldn't it?
I didn't give that any thought, I'm afraid.
All right.
I just simply thought, as a matter of fact, well, I'm not, you know, we certainly haven't provided that level of instruction which Mr. Clark has referred to, and I don't think Post Office did either, or the Royal Mail Group for that matter. That was simply my thought process.
And is the relevance of that failure to the conclusions of Mr. Clark simply something you didn't recognise at the time?
I just didn't think of it.
All right, let's turn to my second topic then, please. I'm wary of the time. If we can just look at the transcript of the call in relation to SAMRA. It's poll 00142322. It's right, I think, that on the 28th of June 2013, you and Mr. Clark made a telephone call to Mr. Jenkins.
Yes.
Is that right?
That's right.
How was that recorded?
I don't recall precisely how it was recorded.
Do you recall how this note was produced from that recording?
No.
Do you recall who prepared it?
No, I don't.
Do you recall when it was prepared?
No.
Do you agree that Mr. Jenkins was given no warning about this call?
I do, yes.
Do you agree that he had no prior knowledge of the case of SAMRA?
I don't believe that he would have known about the case of SAMRA because I don't believe any form of expert report had been sought in relation to that case, so he wouldn't have had any instructions, whether defective or otherwise.
And you acknowledged to my learned friend Mr. Steen that you were at this stage suspicious in relation to Mr. Jenkins. Is it right that this call was to test Mr. Jenkins' credibility, as you and Mr. Clark saw it, by seeing if he would agree that he had provided information to Second Sight about the receipts and payments mismatch bug and the Suspense account bug?
I'm not sure if the call was to test his credibility. I think Mr. Clark just wanted to speak to him to try and get some information to determine how to proceed with the case against Mrs. Samra.
And what information was he hoping to obtain?
I don't recall.
If the call was being recorded, Mr. Jenkins was not told that.
He wasn't told that, no.
And he was given no chance to check the note for accuracy or understanding as to what he had said?
No.
All right. Turning then to the third and final topic that I want to address. You, to a degree, had conduct of the case of Ishak, is that right?
To a degree, yes, yes. I think it got passed around quite a bit, and towards the end it was very difficult to follow with a number of people who had involvement.
Do you recall that at a certain stage in that case, Mr. Jenkins was invited to comment on the first defence statement that Mr. Ishak had produced?
I do, yes.
And if we can please go to Pol 001 19447. Please. We see here an email from you on the 4th of February 2013 forwarding Gareth Jenkins' comments on Ishak's DCS to Mark Ford and Steve Bradshaw. Do you recall reviewing those comments that Mr. Jenkins had made on the defence statement?
I don't recall reviewing them, I'm afraid, but I guess I must have done.
Thank you. And if we can go to the comments that he made, please, which is Pol 000 59602. Thank you very much. Here under Section 1, Introduction, Mr. Jenkins says, I've been asked to comment on the defence case statement in the case of R and Khayyam Ishak. And then he states, I'm not sure that the responses are of much use, and I don't think there is anything that can really be added to my statement as a result. However, if you feel any of this could be usefully added, I'm happy to be convinced. Much of it relates to requiring further data for analysis, and past experience indicates that help may be required in understanding it. So he's referring there to the fact that there's data that might be obtained that would assist in the preparation of the case. Do you agree?
Yes, he's talking about data that can be analysed, and also talking about the fact that the defence may not necessarily understand it. So he's saying that he could assist the defence.
Thank you. And then if we can please go to page 2. And under number 7, part of the nature of the defence is set out in relation to Post Office Horizon software hardware system malfunctioning. And he says, if the defence can specify some examples of this, I am happy to investigate them. However, I would contend that the system doesn't malfunction without leaving some trail to indicate what has happened. Without examining the logs, it is difficult to be any more specific. Do you interpret that as another reference to the ARQ data that could be obtained in this case?
I think I'm not sure if I understood it to be the ARQ data, but I thought that data had been obtained in this case.
Well, data had been obtained in this case, you may remember, and provided to the defence, but was never provided to Mr. Jenkins. Do you agree? Do you remember that?
No, I don't recall that, and I think we were potentially of the view that with Mr. Jenkins being at Fujitsu, he could quite easily look at the data that Fujitsu held.
Did you not understand that he was reliant on Post Office in order to obtain the ARQ data?
No, I don't think I was.
All right. If we can go to page 4, please. And subsection 6. This is the defence request for all Horizon system data for a particular period of time. And Mr. Jenkins states, I assume that this is the data returned in the ARQs by Fujitsu to Post Office Limited. I have not seen this, but would be happy to examine it if required. When you saw these comments from Mr. Jenkins and the repeated offer to look at the ARQ data, Why was it that you did not ensure he was provided with that underlying data?
I was under the impression that he had the data.
Well, we know that, in fact, he is never provided with the data and he tries to obtain it for himself on the eve of trial. Do you recall that?
No, I'm afraid I don't.
Do you agree that in these comments Mr Jenkins is indicating that system malfunctions are possible and could be looked for in the logs?
Yes, and he's also inviting the defence to supply some examples, which is indeed what I was trying to do as well.
And that he's saying he cannot be more specific unless he has examined those logs?
Yes.
Thank you. Those are my questions.
Thank you, Ms. Oliver, and thanks to all the legal representatives of core participants for their discipline in keeping the time limit. That's it, is it, Mr. Blake? There are no further questions.
That's correct, sir.
So thank you, Mr. Smith, for providing 2 detailed witness statements to the inquiry and for answering questions over yesterday and today. I'm grateful to you.
Very well, thank you.
And we'll resume at 9:45 tomorrow morning.
Yes, sir, with Mr. Singh.